Thank you. Be seated, court session.
We're back on the record on 22-117, the Commonwealth versus Karen Reed.
Okay. All right, so counsel, you're aware of our note from the jury. Dear Judge Cannoni, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict, signed by the foreperson. So I want to hear from counsel your view on whether there has been due and thorough deliberation. So let's start with the Commonwealth.
My answer would be no, Your Honor. This simply hasn't been sufficient time yet.
And what does the defense say?
We believe that there has been sufficient.
All right, so I'll hear from both of you in more detail. Mr. Lally, I will hear you.
Your Honor, the jury received this case earlier this week. They've had slightly shortened days, and I'm not in any way, shape, or form suggesting that they haven't conducted their due diligence in regard to their deliberative process, but I would submit that it is far, far, far too early in their deliberative process to even consider giving them any kind of Tui Rodriguez instruction or anything close to that. Furthermore, what the note doesn't really indicate affirmatively that they can't come to a conclusion. It just says that they haven't come to a conclusion through their deliberative process at this time. They're not even asking for one, is what I would say.
All right, thank you. Ms. Gianetti, I'll hear you.
Your Honor, I would disagree with Mr. Lally's characterization of the note. The word exhaustive is the word I think that's operative here. They're communicating to the court that they've exhausted all manner of compromise, all manner of persuasion,
Jim.
and they're at an impasse. This is a case where the jury has the legal instructions. They've only really asked one question, which was to try to get a report that they were not allowed to get. And I think the message has been received that the evidence is closed. They won't get anything more. They've been working essentially nonstop over the last 3-4 days. We're approaching the weekend. They didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock, and they have nowhere to turn. So our position is the jury should be read the Tui Rodriguez model instruction and go from there.
Okay. All right, so you all know that it is within my discretion, I decide. So a case that has been, it's a long case. This is our 4th day of deliberations, but Tuesday was a short afternoon, maybe 2.5 hours. Wednesday, they left early because of an appointment. Yesterday was also shortened a little bit, and this note arrived with less than 3 hours of deliberations today. So the length of the trial, the length of the deliberations, I know the case we heard from 74 witnesses. There are 657 exhibits, very complex issues in this case. I'm not prepared to find that there have been due and thorough deliberations at this point. So I am going to send them back out. We'll bring them in, and we'll do that now.
All rise to the court, please. Jurors entering. Court is back in session. You may be seated.
Right. So, jurors, I'm in receipt of your note. I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict signed by your foreperson. We all know how hard you've been working. Lunch will be arriving shortly. When it comes, I'd ask you to clear your heads, have lunch, and begin your deliberations again. So, or continue your deliberations. All right? So I'm sending you back out.
All rise to the court, please. Jurors, follow me, please.
Got a call stating that Ken Berkowitz, the chief of police in Canton, had seen some items as he was driving by in the melting snow and that he should come collect those items. This seems strange to me, not only because Canton PD is supposed to be recused out of this, but also because it seems strange to send people to a crime scene and tell them to just drive by every day and see if you see anything. It makes no sense to me, but this is what happened and this is what they did. So Berkowitz calls and Buchanan says that he heads over there. He's asked about this on cross-examination, and he says that there was no coordination between himself and Chief Berkowitz about this, that he just got the call and headed over there. He said Lank was actually there too. Berkowitz said that he was just driving by, saw a piece of glass, and started making phone calls. The attorney asked him, "Did you ask Chief Berkowitz why he's driving by?" And the answer was, absolutely not. But they were recused. I don't know. It makes no sense to me, like I said. But he says they were only recused from the interviews. Alan Jackson says that Brian Albert and Higgins had been communicating with Berkowitz that morning, 2 witnesses on the case. And then he goes to the house for evidence, even though he was conflicted out. And that's not suspicious? There's another search done on February 8th and February 10th, where more glass and plastic are found. They seized more shards of glass and plastic. They said 6 items of clear red and black plastic and 14 items of plastic and glass. They didn't bother having crime scene services come out this time since he said that they had already collected so much evidence before. He says that it was located in the vicinity or general area of other things that they had found, and that was good enough for him. The area that Buchanan estimates to be about 30 square foot is what he considers the vicinity. He said that there were items by the flagpole, by the hydrant, in the road, in the grass, and by the electrical box, etc. So Alan Jackson says that his idea of vicinity may be different than someone else's. They also talk about Proctor's handwriting on the evidence bag from that day. It lists the 6 pieces of red and black and clear plastic, but it was not submitted to the crime lab until March 14th. But he says there's no log showing where they were or any kind of chain of custody for the 5 weeks in between. There's another search on February 11th and February 18th. And then on April 28th, the medical examiner tells Proctor that the manner of death could not be determined. This means that she could not rule it a homicide. There wasn't enough information for her to determine that. So the conversation that Proctor had with Trooper DeChico is discussing this ruling. Now, before I talk about this conversation, I also want to note that Proctor has previously testified that never in his career has he ever had a medical examiner tell him that they could not determine the manner of death. He said for every homicide that he's had, he has never had that happen in his career. Now, during this trial, when he testified to it, he said that it was very rare or that it had not happened a lot. But Jackson did point out that his previous testimony not in front of this jury, was that it had never happened. So as he's talking about this to Trooper DeChico tells him it's a rookie move not getting into the meeting with the medical examiner and getting that homicide determination. Proctor says that he and Buchanan had 2 conference calls with her, sent her numerous photos, etc., and laid out the entire case for her. But that wasn't good enough. DeChico said, not good enough. Should have had me and Jeff do it. Proctor responded, if you 2 did it, she would have made it accidental or natural causes. Proctor said in this text exchange, of course it's undetermined. She was a whack job. Trooper DeChico said, dear God, WTF, what the hell is inconclusive about the whole thing? Jackson points out, in front of the jury, here he is again, calling someone a whack job. He asks, who are you referring to? Now, it's worth noting that when he's talking about this during direct examination, he says he's referring to Karen Reed. But the way that Jackson isolates this conversation and shows that there is no conversation going on at this time about Karen Reed, he pushes back on this and he tells him, who are you referring to? And it's very clear in this conversation, he's calling the medical examiner, Dr. Scortibello, a whack job because she didn't give the homicide determination that he wanted. On June 9th, there's text messages where Proctor is telling his wife that he is waiting to lock this whack job up, now referring to Karen Reed again. Now, this is the day that she was indicted by the grand jury, and she was processed in the barracks at Milton. The jury also heard the audio from the body-worn camera that was taken while she was in custody at Milton Barracks. I'm not going to play it because the audio on this one's not great, but we have heard this in a previous pretrial hearing. This is the one where she is talking to the officers about potentially getting bail or how she's not getting bail this time. And she says something to them about the charges. And she says something about her taillight and that we're all in on the joke, right? That Brian Albert and Colin Albert beat John up and her taillight is pulverized and we're all in on the joke. There was no context really given for this to the jury, so they were just kind of told it's an interview. So I'm curious as to how well they were able to hear it and about what kind of questions they have from it. Proctor references this in text to Kokowski and DeChico later that evening. He says something about Karen Reed and her medical condition again. When they're asking about if she's hot, he says, if you like women who shit themselves. Then he says the statement that she made was mental tonight when they were locking her up. He said, thank Christ it was on body-worn camera. Somebody asked what'd she say, and Proctor said, she said that the Alberts beat the shit out of O'Keefe and left him for dead. That's why the taillight was cracked. She's gross. DeChico responded, oh, fuck her, bitch. A conversation with Proctor and his supervisors from August of 2022 is the first conversation that's actually brought up during cross-examination. This is toward the end of the day, and I don't doubt that Jackson brought it up and hammered this in so that the jury went home with this conversation on their minds.
Super Proctor, in the summer of 2022, August 17th specifically, you were sitting at your desk, presumably alone at your office, at about 10 p.m. at night, going through my client's personal cell phone, correct?
Yes, sir.
As a matter of fact, you were sitting there texting with your friends and colleagues at Massachusetts State Police about you going through her personal cell phone. Is that right?
Correct, sir.
And that included Trooper DeChico, is that right?
DeChico, yes, sir.
Trooper Fanning, Trooper Butnick, Trooper Moore, and Trooper Kutzkowski.
Kakowski.
Tell me that again.
Kakowski.
Kakowski.
Yes, sir.
All right, all the consonants are silent. Fair enough. Trooper Fanning and Trooper Butnick are your supervisors.
Yes.
And you were bragging to all 5 of them that you were going through Karen Reed's cell phone about 9:45 at night.
Objection.
I'll allow it.
Is that right?
No, I wasn't bragging, sir.
Trooper Proctor, Trooper DeChico had sent you a photograph of my colleague, Mr. Yannetti, correct?
Yes,
You see that, gentleman?
I do, sir.
Is that the photograph that you received?
Yes.
And then your response was what?
I hate that man. I truly hate that man.
Actually, your response was, I'm going through his retarded client's phone right now, correct?
Yes, after the picture, sir. Yes.
Who's the retarded client?
I was referring to Miss Reed again, unprofessional language.
I'm asking for who you were referring to.
Miss
I know
Reed.
you've got an explanation. Who was it you were referring to as retarded?
Miss Reed.
Karen Reed, the woman sitting to my left.
Yes, sir.
The subject of your investigation as a professional, correct?
Yes, sir.
As an unbiased, objective investigator, the person that you were investigating, you referred to your bosses as retarded, correct?
Again, poor language on my part.
Poor language is one way to put it. Completely offensive is another way to put it, right?
Objection.
I've got to sustain that, Mr. Jackson.
Jackson refers to Proctor saying that he hates Yannetti as a visceral response to someone who is just doing their job. And as he continues the questioning, he repeats the words being said, making sure that the jury feels every bit of the uncomfortable inappropriateness and offensiveness of the words that Proctor wrote. He then asks Proctor about Yannetti and asks, how do you feel about him now?
I still don't care for him now.
Right. I'll let it stand.
The conversation continues to get bad. Jackson brings up the fact that Proctor gave an update to not only his colleagues, but to his superiors in a group chat as he's going through Karen Reed's phone. And he tells them he hasn't found any nudes yet.
I provided a inappropriate joke as an update. They knew I was going through location data, text messages, Google searches. But like I had mentioned earlier, I had to stop.
Except Trooper Proctor, none of that really professional sounding stuff ended up in your comments to your bosses, did it?
Again, it was a poor joke.
Is that yes or no?
I did not know.
It did not.
No,
As a
sir.
matter of fact, what did you write after you talked about going through the quote retarded client's phone?
Objection.
I'll allow it.
No nudes so far.
No nudes so far,
Mhm.
correct?
Correct.
And you said that to your bosses.
Yes, sir.
You were looking for naked photographs of Miss Reed on a Wednesday night as you sat in your office at 9:44 p.m., correct?
No, not correct.
Let me ask you a question. Have you ever looked for naked photos of a male suspect that you were investigating?
I don't look for naked photos on anyone's phones.
But you said you were looking for nudes of Miss Reed,
Like I had
correct?
said, Mr. Jackson, it was an inappropriate joke.
Sir, this is a citizen. She's a woman. You were supposed to be objectively investigating. Does your text message to your colleagues at Massachusetts State Police reflect an objective investigation of a citizen?
Objection.
You can get part of that question and ask it again.
Do you believe that your text messages were reflective of an objective investigator?
Objection.
I'll allow that. Do you believe that, Trooper Proctor?
I believe poor jokes have, in unprofessional language, have no bearing on the integrity and the facts and physical evidence of this case.
It's not that they don't have any bearing on the facts and integrity. It's that they have no place in a professional investigation because it shows bias, right?
Objection.
So I have to sustain that as asked. Go ahead and ask it differently, Mr. Jackson.
You weren't so much as objectively investigating Karen Reed as objectifying her, correct?
Objection.
I'll allow that.
Is that right?
Rephrase the question, please.
You weren't so much as objectively investigating her as objectifying her in those moments, correct?
Again, Mr. Jackson, it was a poor choice of words and a joke that I should not have texted out. But from the start of the investigation, we didn't know what we had.
And your Trooper Proctor, your point in saying no nudes so far to your colleagues in Massachusetts State Police was to suggest that you were looking for nudes and you'd update them when you found them, correct?
Incorrect.
Did you believe that your conduct was a misuse of your authority and power as you were going through her phone in August of 2022?
Objection.
Allow it.
No, I had a warrant signed by a district clerk, Stoughton District Clerk, to go through Miss Reed's phone. I don't think it was an abuse of power. I had every right to go through that phone.
Did the warrant say anything about looking for nudes of my client?
Objection.
Did it
No,
say anything about that?
Your Honor.
Okay, next question.
So that would be an abuse of the power that was given to you by the court, correct?
Objection.
Sustained.
Jackson says the hallmark of any good investigation is that the investigator has to be fair and impartial. The investigation has to be free of bias. You can't be biased against the person that you're investigating because that would compromise the whole thing. Proctor agrees. Jackson says you're supposed to follow the evidence wherever it takes you, good or bad. Just follow the evidence and report back. That's how it's supposed to be run. Proctor agrees. Jackson says it's literally an oath that he had to take at the academy, that he will faithfully and impartially discharge and perform all of the duties incumbent on him as a Massachusetts state trooper. Everyone in the investigation should be treated exactly the same. Proctor agrees. Jackson continues and says everybody is a suspect until they're not. And that's especially important in an early part of an investigation, before all of the facts are known, that the investigator is not compromised by bias, prejudice, because that's when things are most up in the air. There's a cloud of fog of not knowing exactly what the truth is. And Proctor agrees. Jackson tells him, you don't get to pick a suspect and then try to find evidence to support your choice. But in this case, he said, that's exactly what you did, isn't it? That part, Proctor didn't agree with. Jackson asked Proctor if he stands by his testimony that this investigation was done with integrity.
You indicated that your conduct in this case, and specifically your conduct as reflected in these messages, how did you put it? It did not affect the integrity of the investigation, of your investigation, correct? That's what you
Correct.
said to the jurors.
Correct.
You know what the definition of integrity is?
Doing the right thing when no one's looking.
It means the quality of being honest and having strong moral principles, correct?
Objection.
Sustained.
Do you believe that integrity means being honest and having strong moral principles?
I believe that's part of it as well.
Do you stand by that testimony that you were showing strong moral principles in this investigation, sir?
In the investigation part, absolutely. Through these text messages, absolutely not. They were juvenile and regrettable.
When you say they're juvenile and regrettable, it sounds like you're almost apologizing to the jury for your conduct. Is that what you're doing?
For those texts,
Objection.
Sustained.
Trooper Proctor, have you ever apologized to Miss Reed?
Objection.
Sustained.
Jackson brings up all the issues that he wants to address with the jury while Proctor is on the stand. He asks about Proctor testifying that he did not know and did not have a relationship with the Alberts or McCabe's, which we have heard before that he knowingly minimized to the federal grand jury. He says that he said he did not know them or have relationships with them because he interpreted it to mean that they were friends and they communicated. Texts are brought up from 10 days before John O'Keefe's death, where potential arrangements were being made for Julie Albert to babysit Proctor's son, and from about 3 weeks after John O'Keefe's death, where Julie is texting Proctor, laughing and saying, "This is the weekend that I've been waiting for. Please send ski videos if Courtney doesn't share them with her." This clearly shows a relationship of some sort, both before and after the death of Officer O'Keefe. Jackson points out that Proctor did not mention anything about his relationship with Julie Albert, Chris Albert, or Colin Albert on any report that he ever drafted. The same day that he interviewed Julie and Chris, Julie called his personal cell phone less than an hour later, and not long after that, Proctor's sister texted him asking how it went interviewing Julie because she said that she was so nervous. He tells her that it was fine, giving information about his interview of a witness in this case that they have a personal connection to. He also reads texts from his sister, telling him if the victim and his girlfriend were at the bar with Chris and Julie, she probably knows them. And another text the next day saying, Jesus Christ, the party was at one of the Alberts, with 2 exclamation points. He later brings up the notes from Proctor's interview with Julie Nagel, stating that he listed everyone at the house except he left Colin off. And he asked Proctor about him interviewing Colin himself, despite their personal connection. And he says he did nothing to corroborate their story or to verify that he went home at the time that he said he did. Jackson also asks about the Life 360 app from Jen McCabe's daughter who picked Colin up. And he asked Proctor, did you bother to get video surveillance from Canton High School or the gas stations nearby? And Proctor says he didn't, despite a conversation that was also brought up with a Canton police officer who told him about one of the gas stations that had video, and Proctor said he was going to add it to his list. Jackson continues to show the issues with the investigation, bringing up the fact that Proctor interviewed Julie Nagel and Sarah Levinson 7 months later, Caitlin Albert and Brian Jr. 16 months later, Allie McCabe, Ricky D'Antano, and Heather Maxson 18 months later, Lucky the snowplow driver 17 months later. And Jackson says that Proctor told the grand jury under oath that no snowplow traveled down Fairview Road on the 29th. And he asked him, why would you say that? Proctor said that that was based on his interview with Michael Trotta, but Jackson tells him Trotta already testified and said that he did tell Proctor about the plow drivers. He says he basically just didn't want to interview anyone that didn't fit his narrative. Proctor said, absolutely not. He brings up Higgins having the romantic connection to Karen and says that Proctor learned about that within the first 2 weeks, but he didn't think that it was important enough to pursue or to do a forensic image of his phone. He asked Proctor about things being deleted from Jen McCabe's phone before she turned it over, and Proctor said that he wasn't aware of anything being deleted, despite a Celebrite report showing deleted calls and texts, and despite Jen McCabe testifying that police told her that she could delete conversations with her daughter. He brings up conversations with Kevin Albert, who is conflicted out of this completely, not only as a family member, but also as Canton Police Department. But they were still communicating, and he was helping to arrange interviews for Proctor. But the Kevin Albert connection doesn't end there. We hear that Proctor and Kevin are pretty well acquainted also.
So when you told the jury a few minutes ago that you were aware of and knew of, but didn't have relationships with 3 Alberts, Julie, Chris, and Colin, not quite true, is it? There's a 4th Albert out there, isn't there? Yeah, right?
Yes.
But you didn't tell us about that one, correct?
I don't consider that a relationship. It's,
Well, let's look at that. 5 months into this investigation, in July of 2022, you were actually continuing to socialize with Kevin Albert, weren't you?
yes.
On July 19th, 2022, you and Kevin Albert went out drinking together, didn't you?
I don't recall that.
You don't recall the date, or you don't recall,
July 19th, 2022.
you don't recall the drinking?
The date itself, sir.
In fact, the 2 of you got so drunk that Kevin Albert left his badge in your cruiser and couldn't find his gun the next morning, right?
I can't speak to any level of intoxication, but I don't recall either of us being intoxicated.
Got it. So isn't it true that July 20th, 2022, the day after at 8:39 in the morning, you texted Kevin Albert, quote, found your badge in my cruiser this morning, end quote, correct?
Yes.
Then you texted him, I can leave it in my locker at the gym, drop it off at your station, or leave it in my mailbox, correct?
Correct.
Kevin Albert responds, my mailbox. Did I take my gun? And then included a wince face emoji, correct?
Correct.
So the fact of the matter is, you two got so drunk that he couldn't find his badge and had to ask you the next morning where his gun was, right?
Again, I can't speak to any level of intoxication, whether he just forgot it. I don't
I'm
know.
not asking you about his BAC, Trooper Proctor. I'm asking, have you seen drunk people before?
Yes.
You've been drunk before.
Yes, I have, sir.
We've all been drunk before, right?
Yes.
Was he drunk? Were you drunk that night?
I don't recall. It was a long time ago.
But he left his badge in your cruiser after a night of drinking. Isn't that right?
Yes.
Which means you were drinking and driving in your cruiser, right?
From what I remember, we were down the Cape working on the cold case together and stopped for dinner, had a few beers, and then dropped him off.
Kevin texts him later, talking about how hungover he was all day and said that he's going to have a couple tonight to make him feel good. Now, the problem with this isn't the drinking or the being drunk. There are multiple problems, but that ain't it. The problem is that this is yet another Albert that Proctor has a personal relationship with. The problem is that he lied to a grand jury about not having a relationship with any of them, which shows his lack of concern for the process of justice. The problem is that he was driving his police cruiser drunk, which shows his lack of concern for the law and for his position. The problem is 2 cops got so drunk in the police cruiser that one of them couldn't even find his gun or badge. But don't worry, nothing to see here, right? Jackson brings up multiple reports saying that Proctor seized Karen's car from her parents' house at 5:30, but the actual time was 4:16. Proctor said it's a typo. Jackson said, so you got the 4 wrong, you got the 1 wrong, and you got the 6 wrong. And those turned into 5 and 3 and 0, right? In his final moments of closing, Jackson brings up a text that Proctor sent to his sister, and then he wraps things up in a very tense moment.
And your response was, hopefully she kills herself, correct?
Yes.
You literally said that you hope that Karen Reed, the subject of your investigation, the woman sitting to my left about 7 feet from me, that she would just die, correct?
The figure of speech.
You wanted her to, the figure of speech is you wanted her to kill herself,
No.
right?
No, it's not.
Trooper Proctor, Karen Reed, in your investigation, had quickly become a very serious problem for you, hadn't she?
No, absolutely not.
In your words, quote, all the powers that be want answers ASAP. That's what you texted on January 29th, right?
Yes.
That put a lot of pressure on you, didn't it, Trooper Proctor?
There's a lot of pressure in every case, sir.
This case involves a Boston cop whose family you were actually connected to, correct?
Loosely.
Chris Albert, loosely.
Yes.
Julie Albert, loosely.
Yes.
Colin Albert, loosely.
Yes.
Kevin Albert, loosely.
Yes.
Loose enough to leave his badge and his gun in your cruiser when after a night of drinking, right? You agreed in your group chat that you needed to, quote, make this cut and dry because another cop was involved. Those are your words, right?
I did text that. I don't know if it's in the exact context. But yes, those were my words.
Group chat.
Yes, that was in the group chat.
Your friends wrote this whole thing in their words, stinks, correct?
Yes, I interpret that as a joke.
You believed, Trooper Proctor, that your life would be much easier if Karen Reed was just dead, didn't you?
No. Like I said, it was a figure of speech. My emotions got the best of me based on, the fact that Miss Reed hit Mr. O'Keefe with her vehicle and left him to die on the side of the road. So my emotions got the best of me with that figure of speech.
Well, let's talk about your figures of speech. During the course of your investigation, your figures of speech include the following. She's a bitch. Is that right?
Yes.
A whack job, correct?
Yes.
A retard, right?
Yes.
Her balloon knot leaks, right?
Yes.
No ass, correct?
Yes.
She's fucked, according to you, right?
Yes.
Ass leaker. That was the word you used, a figure of speech, right?
Correct.
A girl who shits herself, right?
Correct.
And then fuck her, correct?
Correct.
Would you agree, Trooper Proctor, that you have dehumanized Karen Reed during the course of your investigation with comments and words like this? Would you agree with that?
I would say based off that language, yes.
And you admitted in your own words that the cop homeowner wasn't going to, quote, catch any shit, right?
Correct.
Because you were out to quote, make this cut and dry. Isn't that right?
The homeowner wasn't going to catch any shit because Mr. Elba had nothing to do with Mr. O'Keefe's death.
Because you were going to make sure that the case was cut and dry. Those were your words, right?
Objection.
Sustained.
And Trooper Proctor, it would be far easier for you to pin it on the girl who's just a whack job cunt, in your words, who you hope just kills herself, right? Shame on you, sir.
The judge tells the jury to ignore that comment, and it is stricken from the record. Lally gets up and does his redirect. Now, he gives Proctor the opportunity to say why he doesn't like Yannetti.
Well, basically, he stood up in open court and spouted lie after lie about me, called me corrupt and conflicted, dragged my name through the mud after I spent 10 plus years without a single complaint filed against me. And he had no basis or no facts for these wild accusations because there are none. This investigation was done with the utmost integrity, not just by me, but my supervisors and other troopers in my office, as well as Mr. Yannetti shows up at my sister's school yesterday in the parking lot where he's not welcomed or where people are not supposed to be, with one of their witnesses and their private investigator. And a teacher sees this, informs Mr. Yannetti that he can't be there. And instead of saying, okay, and leaving, he asks, is Courtney Proctor in the building? Does she work here? She calls me to see if she was being served.
Objection. Can we approach?
Yes.
First time Proctor's been on the stand that he didn't have any trouble speaking up. The jury is taken out of the room while the judge talks to the attorneys. Yannetti was asked after court about being seen with Lucky, the witness that Proctor mentioned. And he said, yeah, of course he was meeting with him. That's one of their witnesses. And he met with him at the school at Lucky's request so that they could go over the route and prepare for his testimony coming up. When the jury's brought back in, the judge tells them to completely disregard that last answer. And if they wrote it down, cross out the notes. They are not to consider it in any way. Proctor is given the chance to answer the question again with a little more direction on his limitations. And he says that his feelings about Yannetti are because of false accusations of being conflicted and corrupt, spouted in open court, which there's zero evidence of. Lally also asked Proctor about allegations of children in a photograph. Finally, the photo is addressed. Now, this is a picture that we've talked about before that was discussed in court. The picture has been controversial in court and social media for a year now. When Lally addressed it in court at a pretrial hearing, he didn't clear anything up because he referenced the children and then he corrected himself and said the child is Proctor's family member. But the child that he referenced isn't the one that the defense was saying is one of the McCabe children, or two of the McCabe children, actually. It was actually the two in the back of the photo. So his correction and his vague response did nothing but fuel the fire. This is something that I've brought up in previous episodes. And finally, we hear Proctor address it the way that Lally should have addressed it the first time it was brought up. Proctor says that this was his family. He also says that the reason that he interviewed Colin is because Colin was the subject of a third-party culprit defense, and he says that there was no evidence to back that up. He says that he didn't respond to the text to Julie Albert about the ski trip videos. He doesn't even remember the last time that he talked to Chris and Julie Albert before the investigation started. He said that the case that he was working with Kevin Albert was a cold case, and he asked to drop off his badge, so he needed the address. And Lally suggested that that shows that he didn't know Kevin all that well. And finally, Lally asked Proctor why he made those terrible comments about Karen Reed. What he thought at the time happened that made him so upset that he would make those comments. And Proctor gives his explanation to the jury of what he thought happened that night at Fairview Road.
I believe, based on all the physical evidence and facts, Mr. O'Keefe got out of that vehicle holding that cocktail glass he walked out of the Waterfall bar with. Ms. Reed pulled ahead and then backed into him, struck him with her vehicle, and then left.
Then came back 5.5 hours later, correct?
Correct.
Nothing further.
Jackson says that does not give Proctor a right to use those words that he did or to speak about his client the way he did. And he repeats some of those things that he said, leaving the jury with the impression and the memory of it. He told Proctor he had an agenda from the beginning, and he compared his being the lead investigator on this case to a fox guarding a hen house. I know that this was a really long episode, but I wanted to put everything from the two main investigators together into one episode to make it more cohesive. I didn't want to break it into two. And the next episode will probably be another supersized episode. It's going to have all of the experts. These are the final witnesses in the Commonwealth's case. Were they able to put everything together to clear up questions? We're going to hear from the data experts. We're going to hear about the data points, about GPS and the step data, all of these things we've talked about before. This is conflicting data, so what do the experts say about it? We'll also hear from the medical examiner and one of the most controversial witnesses that we've had so far, even more so than Proctor maybe, the crash reconstructionist, Trooper Paul. All of that will be on the next episode. We still have a lot to cover, and we're one step closer to this case going to the jury for deliberation. My name is Brandy Churchwell, creator of 13th Juror Podcast. If you're enjoying it, please leave us a review on Apple Podcasts and Spotify, and share this episode with your friends. For more information, photos, and episode guides, visit our website at 13thjurorpodcast.com.
The trial of Karen Reed for the death of her boyfriend, John O'Keefe, is underway.
There are 17 jurors, and they're coming and going.
I see it's coming to an end. So that was the most recent one. I'm going to go back to the one right before that. This is episode 18. I'm going to keep it playing so that I can keep working. I love you. I miss you, but I'm right here.
With a police escort.
I've seen a lot of things. I've never seen anything like this. This case never ceases to amaze me.
The first week of testimony has come to an end.
It's a spectacle, that's for sure.
We really heard the defense highlight some of the discrepancies between what was documented and what first responders said they remembered.
There are a lot of issues in this case.
Proctor was improperly searching Karen Reed's cell phone for nude photos.
The fact that the investigation wasn't thorough provides a big wrinkle in the prosecution's case.
They're supposed to be creating this reasonable doubt, and they're doing exactly that.
Everybody wants to know, us included, why he wouldn't go inside that home on the night that the body was discovered.
There are more people here at the beginning of this than at the beginning of Johnny Depp's trial.
It's always the theories or stories that each side will put forth, right, for a jury to listen to and decide which one is more believable.
We asked Karen Reed about that alleged confession. Karen, did you ever say I hit him?
I did not.
The FBI is investigating an investigation of a murder. That never, ever happens.
Karen Reed was drunk and angry and hit and killed John O'Keefe when she gunned it in the snowstorm.
We're looking at arm injuries with scratches. We're not looking at tire tracks.
I did not kill John O'Keefe. I've never harmed a hair on John O'Keefe's head.
Defense attorneys learn in school, first class, the most important thing you can do is identify and select stupid juries.
We're not concerned about any of the witnesses. None of the Commonwealth's witnesses are concerning us.
Karen Reed is facing up to life in prison.
I just hope justice is served for either one, whatever it is, you know.
The fate of her life is not in her hands anymore. It's not in the hands of her attorneys. It's not in the hands of the prosecutor. It's in the hands of the jury now.
Free Karen Reed! Free Karen Reed! Free Karen Reed! Free Karen Reed! Free Karen Reed!
We have so much to catch up on, so I promised y'all a bonus episode this week along with the regular episode. I don't want to waste any time, so let's just jump right into it. Higgins wrapped up his testimony on the morning of day 18, at which point the cameras in the courtroom were turned off and no online streaming or reporting was allowed for the next two witnesses. John's niece and nephew, who are both still minors, were brought in to testify. Because streaming wasn't allowed for them, I can only give summaries of what was said based on the reporters' notes that were in the courtroom. Reporters weren't allowed to give live updates. No recording, no streaming, no live tweeting. Everything was done through taking notes and then reporting on what happened and what was said after the interviews were over. They were also asked not to use the niece and nephew's names in their reporting. The children weren't on the stand for too long, less than 2 hours total, and they were asked some of the same questions about John and Karen's relationship, what they witnessed, and of course, John's niece was asked about the morning of January 29th. His nephew testified that the relationship between John and Karen was sometimes rough. They had disagreements and arguments with yelling that became more frequent closer to John's death. His niece said their relationship was good at the beginning, but got bad toward the end. There was a time, sometime that January, where Karen and John got into an argument, and his niece said that John told Karen the relationship used to be fun and now it wasn't. It had run its course, so Karen got loud and was swearing. John's niece said that John told Karen to leave, but Karen didn't. They were both asked about the argument in Aruba, which they heard. John's nephew said that Karen was nice most of the time and she would take them places. Both kids said that when she was upset, it usually resulted in Karen kind of ignoring or not looking at them. And his nephew said that there were a few times that they got in trouble and got yelled at. He gave an example of getting takeout food one night, and Karen got mad because she said that they didn't seem to appreciate it. So she put up a little bit of an attitude. John's nephew said that on the morning of January 23rd, Karen came over and looked sad. She was crying. I didn't see any of the reporters mention the significance of this date, but I do know that the 23rd was a Sunday morning, which is the day after John and Karen had gone to Hillside and hung out with Brian Albert and Chris and Julie Albert and the McCabe's and some others. One of the things that was interesting was the niece being asked about Karen's access to the computer upstairs. Part of the Commonwealth's theory is that Karen deleted Ring videos from John's Ring camera system on the computer. His niece was asked if Karen had access to the computer, and she said that she didn't think Karen had an account on the computer, but she could go in the room. Now, the defense theory seems to be that Karen didn't delete those videos, which is why they requested them from Ring and tried to get access to them. We know that they were accessed through John O'Keefe's Ring app on his phone, but that was done by the police, not Karen. And the information that they received from the subpoena from Ring doesn't have any information of deleted videos on the activity log. So this will be something that the jury will have to decide. We know that the police had access, but did Karen? John's niece gave her recollection of the morning of January 29th. She said that Karen woke her up around 4:30 a.m. and had her call Jen McCabe and some others. On one of the calls, she said that she heard Karen ask, "Could I have hit him?" or "Did I hit him?" Although Yannetti says that this was never mentioned during the interview on February 2nd at the DA's office. His niece said Karen was really on edge. She had never seen her that frantic. She was pacing around, and as she was calling more people, she was saying different things, like, "Did I hit him?" or "Did a snowplow hit him?" And in one conversation, she mentioned an argument, but in another, she didn't. She said that Jen McCabe, however, was relaxed. She told her that everything was going to be fine, and she was much calmer than Karen was. His niece also confirmed what we've heard about the garage door not closing that morning and said when Karen came back to the house after leaving the hospital, she remembers she went upstairs at some point. She said that Karen said that she felt like she was living in a nightmare and she left the house. Yannetti asked each of the teenagers if they knew the phrase, "raise a hand in anger," and asked if John or Karen ever had, and both kids said no. Yannetti concluded his brief cross-examination of John's nephew by saying, "I'm so sorry that you were made to come here today. Nothing further." At which point, Judge Beverly Cannoni struck the comment from the record. Outside the court after that day, Yannetti said that the prosecution's decision to call the children to testify was a desperate and inappropriate attempt to try to prove a non-existent motive that they failed to prove through their adult witnesses. The next witness to take the stand was Dr. Justin Rice from Good Samaritan Hospital Emergency Department. Dr. Rice referred to a copy of the medical chart for Officer John O'Keefe that he said that he would have dictated or produced, and also a code sheet that the nurses would have put together, and he would generally sign off on it, detailing whatever resuscitative efforts were made or performed on John O'Keefe's behalf. Dr. Rice said, according to the chart, Officer O'Keefe arrived in the emergency department at 6:47 a.m., unresponsive and intubated with a breathing tube into his airway. CPR was in progress, and an endotracheal tube was being used to ventilate his lungs. He arrived in cardiac arrest, meaning his heart stopped functioning. So the CPR being performed was in an effort to force the blood to flow by physically pushing on his heart. Without the blood flowing from the heart, the organs begin to shut down, and a lack of oxygen to the brain after a certain amount of time can cause brain death or neurological issues. In the emergency department, Dr. Rice and the rest of the team are focusing on resuscitation efforts to prevent this if possible, and there are guidelines to how to do so. He explains that epinephrine, which is basically adrenaline that was used on John in hopes of increasing pressure and impacting the electrical function of his heart. Dr. Rice also discusses hypothermia. He said John's initial body temperature was low. The nurses documented his internal body temperature at 80.1 degrees Fahrenheit. Since cardiac arrest causes your blood to stop pumping, your body temperature will decrease over time. Average normal body temperature is 98.6 degrees, so John being at 80.1 falls in the parameters of hypothermic. Resuscitation efforts were made for this as well. They tried to warm him in a bear hugger, which is basically a blanket that has warm air being pumped through it. And they gave him an IV with fluids that were warmed in an oven of sorts. The idea is that if they are able to warm the body, the heart and other organs will function better. Unfortunately, after about half an hour, Dr. Rice said there wasn't a significant warming of John's core temperature, and he was pronounced dead at 7:50 a.m. Dr. Rice also gives the notes from his physical exam. He said that John had a 7-millimeter laceration on his right superior orbital ridge region. Now, this is the bone area above your eye socket. Think like where your eyebrows are. A laceration means that the skin was torn, usually by a sharp object, and a standard staple is about 8 millimeters long, so that gives you an idea of how big 7 millimeters is. There was also swelling of the soft tissue around this area. Dr. Rice says that John didn't have a pulse, and the abdominal exam was atraumatic, meaning there wasn't tissue injury, and John had superficial abrasions on his right forearm. Dr. Rice explains that abrasions are synonymous with scratches, so this would be where skin is rubbed or scraped off as opposed to a laceration with something sharp. Dr. Rice was also in the emergency department when Karen Reed was brought in, and he reads on her chart that her first vital signs were done at 7:51 a.m. Lally asked Dr. Rice what his typical involvement is on a patient that comes in under Section 12, and Dr. Rice explains that that can vary a lot depending on the patient and the nurse or nurse practitioner. An evaluation is done, and then they decide based on that if there's a need for a mental health consult. Vitals are done and sometimes blood work. The blood work can answer some questions for the doctors. For example, if the patient is intoxicated on alcohol, it wouldn't necessarily be appropriate to do a mental health evaluation because you're not going to be getting a true representation of what's going on. The process is basically to try to clear the patient medically and psychologically. Lally asked Dr. Rice if it's typical to draw blood for Section 12 to look for drugs or alcohol. And this is Dr. Rice's answer.
I mean, I'm hesitant to answer yes because of the word typical, because I wouldn't say there's really a typical presentation with respect to mental health presentations in the ER.
Dr. Rice said blood work was drawn for Karen Reed, and the alcohol screening came back as 93 milligrams per deciliter. During cross-examination, defense attorney Elizabeth Little asked Dr. Rice about treating Karen Reed. Dr. Rice said he was involved in her care, but he doesn't remember treating her, and he didn't write the reports regarding her care. They were done by a nurse practitioner. Little asked Dr. Rice about the blood collection.
Do you recall treating Ms. Reed at all?
No, I don't.
Do you recall actually ordering her blood in this case?
No,
Do you recall sending it out to the labs at all?
no,
As you sit here today, you don't know who collected the blood?
that's correct.
You don't know who packaged the blood?
That would also be a fair assessment, yes.
And you don't know who submitted that to the labs?
Correct.
And it wasn't you, correct?
I can confidently say that I did not collect blood work. I did not do that.
Okay.
Now, look, I saw that Dr. Rice got a lot of heat for this exchange. As someone who spent a lot of time in hospitals and emergency departments when I was going through cancer treatment, I can tell you that it is not strange that a doctor didn't have part in collecting Karen's blood. It's usually done by a phlebotomist or a nurse. And it's also not strange that he doesn't remember Karen specifically. Good Samaritan Medical Center is a level 3 trauma center, and the emergency department has 42 private rooms, plus 6 fast track rooms, 9 ambulance bays, an imaging suite, an EMS room, decontamination room, double trauma bay, and 2 bays for cardiac care. Dr. Rice has seen a lot of patients in the last 2.5 years, so it's not expected that he would remember a Section 12 from 2022. Another interesting moment in the cross-examination came when Little asked Dr. Rice about treating John O'Keefe. She asked if a firefighter approached him that morning to tell him that the victim had been struck by a vehicle. Now, you'll remember that part of the testimony from Anthony Flamati was that he relayed that information to the hospital when they took John O'Keefe in. But Jackson pushed back on that, saying that he never wrote that in his narrative and had never said that to anyone else before the day that he testified in this trial. So Dr. Rice said that he doesn't remember a firefighter approaching him to inform him of this, but he thought that he remembered it being in the report that an EMS had told them that. Little, of course, had the report available, and after looking at it, Dr. Rice acknowledges that there is no mention of a vehicle anywhere in the report after all. Dr. Rice agrees that there's no mention of any broken bones or fractures from the neck down anywhere in his report of Officer O'Keefe. But he says their focus and the focus of his team was on resuscitation efforts. So there wasn't the extra focus on injuries or observations that don't coincide with those efforts. Basically, they were trying to save John. They're not doing a full skeletal x-ray because that's not within the realm of resuscitation. The next 2 witnesses were Dr. Gary Fowler and Nicholas Roberts. Now, I want to talk about them together because they are both testifying to discuss the blood alcohol levels and conversion methods for Karen Reed. Dr. Fowler is the chief of pathologists at Good Samaritan and also the lab medical director. His job is to ensure the quality of the anatomic pathology side of things as well as the clinical pathology side of things. Basically, making sure that any lab reports coming from Good Samaritan are accurate. For the blood test, Dr. Fowler says that the phlebotomists don't use alcohol wipes when testing for alcohol so that they don't contaminate the sample. And he goes over the policy for how things are done. I'm not going to bother going into details on this. It's all pretty standard stuff, like having the patient say their name out loud and checking it against their ID bracelet, etc. Dr. Fowler explains that in the hospital, they are in the business of reporting alcohol in serum or plasma, not in the business of the legal aspects of testing for alcohol. So they don't make any conversions. That's not their thing. In order to do conversions, they'd have to validate and do a bunch of studies, and they're just not there for that purpose. Dr. Fowler said that he knows that there's a formula that can be used, but says that there's varying opinions on that formula. This is really interesting, and attorney Elizabeth Little questions Dr. Fowler on this during cross. There are differences in screening tests conducted in hospitals and forensic tests that are done in labs. The testing that Dr. Fowler mentioned is to get quick diagnosis and treatment of a patient, which is why they use serum tests. They're not measuring alcohol directly. It's actually measuring the presence of a byproduct that's created when the body is breaking the alcohol down. There are some factors that can cause the test to appear elevated, and Dr. Fowler says that their machine will flag those as possible interferences. And in some cases, it won't even let them complete the test. But there were no flags that showed up on the testing for Karen Reed's blood. Dr. Fowler mentioned not being involved in the forensic type of blood testing and not being involved in the conversions. But the next witness, Nicholas Roberts, is a forensic scientist at the Massachusetts State Crime Lab, and he does exactly that. Roberts is the one who used the formula to convert Karen's 93 milligram per deciliter serum alcohol reading to a possible range of blood alcohol content. Using the formula to calculate the blood alcohol content at various times prior to the blood sample being drawn is called retrograde extrapolation. This was actually the subject of one of the pretrial motions from the defense, who wanted to exclude this testimony since the blood was not collected from the police or at a forensics lab, and the range of Karen's estimated blood alcohol level is a pretty wide range. Roberts said that they calculated it to be between 0.07% and 0.08% at the time of the blood draw, but the range estimated at the time of John's death is between 0.135% and 0.292%. For reference, the legal limit for a DUI is 0.08% in Massachusetts. So that range is a huge swing, like 120%. And Lally said in the pretrial motion that that's because math. In order to calculate this, Roberts used 12:45 a.m. as the time of the last drink and 9:08 a.m. as the time that the blood was drawn, of course. The estimated time of 12:45 may be off some, but Roberts said that it won't change the calculations too much if it's within minutes, because they do their time calculations in about 50-minute intervals. Another problem with these estimates, and another reason that the defense argued to have them excluded, are the issues with so many unknowns. The serum to blood conversion can vary a lot from person to person, and the time of the last drink is unknown. And with so many unknown variables, it's impossible to get a more narrow estimate. Also, since Massachusetts State Lab didn't collect the blood themselves, their retrograde extrapolation calculations don't actually meet their accreditation standards. Another reason that the defense fought to have these excluded. This show is sponsored by BetterHelp. This year has flown by. I cannot believe that summer is already here. What's something that you're proud of in 2024? Is there something that you still want to accomplish before the end of the year? When life goes fast, it's important to take a moment to celebrate your wins and make adjustments for the rest of the year. Therapy isn't just for those who have experienced major trauma. It can help you take stock of your progress and set achievable goals for the next 6 months. It's helpful for developing a positive outlook, learning healthy, productive coping skills, navigating relationships, and it empowers you to be the best version of yourself. If you're thinking of starting therapy, give BetterHelp a try. It's entirely online, designed to be convenient, flexible, and suited to your schedule. Just fill out a brief questionnaire to get matched with a licensed therapist and switch therapists at any time for no additional charge. Take a moment. Visit betterhelp.com/juror today to get 10% off your first month. That's BetterHelp, HELP.com/juror. Next up was Michael Trotta, who has been the Canton Public Works Superintendent for more than 20 years. Mr. Trotta has a long list of responsibilities, including overall operations and long-term scheduling. In February of 2022, Proctor called Mr. Trotta to ask about the procedure for staffing a snowstorm. Mr. Trotta explains that the town is divided up into almost 30 different plow routes for the drivers, and Canton has almost 40 trucks. Plus, there were another 30 private trucks. Usually those are a little bit smaller. They try to have 2 trucks on every route, but it's not always possible when they don't have enough. He tries to have 1 town truck assisted by 1 private truck that is procured through a bid process. When they know that snow is coming, they usually try to set up the schedules about 12 to 18 hours before so that the drivers know what to expect. Mr. Trotta said that when Proctor called, he thinks he asked who was assigned to Fairview area to plow. Mr. Trotta has what's called a plow plan, and the one for the day of the snowstorm from January 29th is entered into evidence. They discuss this document, and Mr. Trotta explains that the drivers go out in stages. So there's a crew set out to go at 2 a.m., and then the private contractors go out at 3 a.m., and it was all completed, and everybody went home at 5 a.m. On the route for Fairview was Brian Laughlin, aka Lucky, in a 4300 International medium-duty truck. Mr. Trotta estimates that Lucky would have been sitting up about 4 to 4.5 feet. For comparison, he says that's about 2 feet higher than you would sit in a standard car. He thinks that he may have identified Lucky for Proctor, but he said that he doesn't have a memory of his exact questions. He said he does remember that Proctor asked him about the plow list, and on that list is a company called By the Yard, which is one of the independent contractors, and a first name and last initial for their drivers. And Mr. Trotta said that he knows that Brian L. would be Brian Laughlin, and he thinks that he may have told Proctor that and referred him to the operations manager to double check who was on plowing that day, just to be sure. He said that Proctor didn't ask him that day to talk to Lucky on the phone, and his conversation with Proctor actually only lasted about 2 or 3 minutes, and he doesn't remember Proctor ever following up with him after that. Now, it's important to remember, he's talking about this plow schedule and having Brian, Lucky, Laughlin on the schedule. And remember, Proctor did not talk to Lucky until like 21 months later. We moved through witnesses pretty fast on day 18. After Mr. Trotta, we heard from Louis Jutras, who works in the Information Systems Division for the Town of Canton Finance Department. And he was asked to provide surveillance videos from the Canton Library security cameras. Jutras said that Lieutenant Gallagher contacted him and said that the state police would be contacting him to request some video footage. When the trooper reached out, he asked for footage from the Pequiside farm and for anything at Town Hall or the Canton Library that faced Washington Street. The timeframes requested were between midnight and 1 a.m. and between 5 a.m. to 6 a.m. on January 29th. Now, the video from the farm is one of the possible routes that Karen can take from Fairview or Jen McCabe's to John's house. And those cameras cover mostly the property and less of the street out front. But there is one camera that's facing down the driveway directly to the street. The library video is motion activated, and the video gets overwritten usually after about 30 days. Now, the request for the video came in by February 7th, so that was plenty of time, and Jutras put the videos together and sent a file share link with the information to the troopers. He wasn't told what kind of car to look for or anything like that, just the times. So he didn't actually watch the whole video or anything like that. He just checked it for the timestamps at the start and at the end. Now, remember, the defense said in a pretrial hearing that there is footage from the Canton Library that's missing during the 2 minutes that Karen Reed would have been driving by. And they said that that footage would show her taillight still intact. I'll be honest, when you look at the video, it's not footage that I think would be clear enough or close enough to exonerate her if the taillight is or isn't broken. Some of the video that has been closer and clearer is still really difficult to see, but the defense has brought this video up before. The problem, according to the pretrial hearing, is that they didn't get the file share link password that was given to the troopers. And by the time it was given to them, it had expired. So the copy of the video that they have from the library is the copy that the troopers and the prosecution made from their access to the file share link that is now no longer available. So keeping this in mind, there was a moment when Lally went to enter the video as evidence, and the witness looked at this disc and said, "That's not mine."
So I'm showing you a disc. Just ask you to, as far as that video from the Canton Public Library, you've seen that video subsequently, is that correct?
This disc with the wording on it?
Yes.
No, I have not seen this.
Not that specific disc, I'm sorry, sir, but the footage, have you been shown that particular video footage, or did you review that footage before you gave it to the troopers?
This is not mine to the trooper.
Okay. Yannetti asks on cross-examination about missing footage, and Jutra says that he didn't watch the video, so he wouldn't know if anything was missing or not. He only checked the timestamps requested and sent a link, so all he knows is that he didn't delete anything. He said that the troopers could have asked him to download and preserve the video so that it didn't get overwritten, but that wasn't a request that was made to him, so he didn't do it. So the raw footage is gone. Jujas also says that part of his duties are the GPS on the town trucks, and he received notification on February 1st from the operations manager that the GPS on the trucks was not working during the snowstorm. Now, this isn't too unusual, apparently. He said that it happens several times a year for various reasons, sometimes related to the network. We got to see the video, and you can also see in the clips that it showed, there was not a lot of snow on the ground at all during the video clips from midnight to 1 a.m. There was a lot more snow on the ground, of course, between 5 to 6 a.m. On day 19, we had our first member of the Massachusetts State Police finally take the stand. Lieutenant Kevin O'Hara gave us an introduction to the Special Emergency Response Team, or CERT, and the collection of evidence from the search later in the day, after Canton PD was gone. O'Hara is the team commander, and he testified that Lieutenant Brian Tully, who is the lead. All right. I'm not done working, but I want to stop for a second because
They don't like our First Amendment right. It sure as hell like them. When I walk
This
in
is-
it's true water. Thank you for cooling me down. But they don't like anybody else's First Amendment. Only they don't like our First Amendment right. It sure as hell like them. When I walk in it's true water. Thank you for cooling me down. But they don't like anybody else's First Amendment.
so do you want to know what I think? This doesn't have a damn thing to do with First Amendment rights. This doesn't have anything to do with supporting the family. This is not support. This is let me go cause a scene. The Free Karen Read people that have been out there during this trial stayed behind buffer zone, did whatever, had to do. They even said something about what the locals were saying, that they were like even picked up their trash and stuff. They cheer and go crazy for Karen Read. They believe in her innocence. They support her. this is not them supporting the family, in my opinion. And if you don't agree with my opinion, I don't care. It's not going to change my opinion if you agree with my opinion or not. This is not this is not what that is. Like kind of like trolling people on Twitter and being a hateful bitch is not supporting the family. Being a part of the problem of how people are behaving is not supporting the family. Trying to keep the animosity going is not part of victim advocacy. I don't know why let me pull up. I mean, there's more. There's more of this nonsense. It's if you want to, if you want to support. The hate and the vitriol is not support. It's instigating. Let me find the other ones. If you want to support Karen, support Karen. If you want to support whoever they say they're supporting, I mean, because it's not even about supporting the family. Like the ones that some of the ones that are saying this are not even. It's not supporting the family, and it's not supporting John. It's provoking stuff with and instigating stuff with people who you don't like. It's like anti-Turtle Boy as opposed to if you don't agree with the way other people look at it, fine. Don't be an asshole about it. I don't understand. I don't understand why you why anybody thinks that starting a bunch of fights is going to be the best way to advocate for somebody. How, since when? Since when? Honest question. Honest question. Has your mind ever been changed by somebody screaming at you and trying to bully you? No. So if you are very much set on one side or the other, fine, be set. But screaming at people and causing a scene and starting a bunch of nonsense and launching hate campaigns and posting people's families and whatever, none of that stuff is going to change anything. I'm going to say this. If something ever happens to me and everybody disagrees on what happened, I don't care. Let everybody disagree. Do not go acting a fool, because that would be way harder on my family than just knowing that everybody disagrees. If I find out y'all are acting a fool when I'm gone, I'm going to come back and haunt every damn one of you. Does my face look weird on camera? Look washed out. This is
How do you guys feel about all the people that have been out here? You guys have that they should all be ashamed of themselves. They're treating this like a recreational activity. Please not you to file John's grave on the anniversary of his death.
Let's get behind the buffer zone, please. It's 200 feet. Come on, guys, let's move it down. Get down, please.
Get a restraining order. There's an active order. Active order.
We have an order on her.
Active order. Yeah. There's an active order.
Guys, you're right. John, this is ridiculous. Goddamn goodness, come on, man.
Listen, I'm letting you know there's an active restraining order.
I'm telling you, you want to
find out about it.
You have a district court right there. That person can go. We're dealing with this.
Okay.
I'm not dealing with the fucking string.
Okay, guy, I gotcha. I'm not dealing with the fucking restraining order. Quote. We all went this way. We went not nothing way, right? Where they are? Where are they?
Family, baby, let's go.
Parker should have thought of his family. Tell Walker he should have thought of his family.
Going to get
And I realized I was misled. The real boy lies about everything. So he was to get her out. The FBI investigation caused reasonable doubt. That should have never happened. How do you feel about the hung gun today? I'm glad it's just not killed. And you can say with confidence.
Let's go with books and
Thank you. I think I clipped him. Saw that I know family has been harassed endlessly. Yesterday, even when he went down there to harass the O'Keefe family, I'm upset. They died. He's lost his life because the children lost 3 adults that took care of them. People are online making fun of John's mother, saying, "Oh, she lost 2 out of 3 kids." What's wrong with her? They are saying the most evil things. Why did you guys come out today? This has been going on for a while now. Why today? Because this isn't normal to even be out here in the first place. Yeah, I stream it every day. I stream it every day, but it really bothers me if they don't have any. That's why we're here. They harass the women to agree. When we are telling the majority win. You stand for the right thing. Even if you stand for stand for John O'Keefe, an abomination. It's recreation. Like it's not. I think it's all fun. I think there's probably one holdout, but I think a hung jury is better than a not guilty. The family needs justice, and John O'Keefe needs justice. This circus isn't giving it to them. The family can't even go to a VFW and wait out a jury verdict without being harassed. That's it.
Back up, back up.
They don't like
Let's go.
They sort of like
Karen Reed supporters, back up. Let's go. Don't pay attention to it. Don't give her any. Let's go.
Only they're own. Is there one piece of evidence that really makes you think Karen did it?
I mean, there's about a million things.
Her car did a lot. She did it. She said she did it. Every single time. And how many statements that she did it? There is a car that indicates like 24 miles an hour in reverse. Just an impact. There is taillight around both bodies. So even if the family is inspired by this, I'm acceptable. You would want it to happen to your family. Would you want it to happen to your family?
I would hope not. I would hope every single one.
What do you make of the tip off? I think that they are deliberating on evidence. I would assume that their hang up is intent because I don't know that I'm even told that she meant to do this. But she certainly didn't. Why did you come to that? I did show the support.
To support the family who's been relentlessly mobbed and harassed. You know, like internet rumors and lies, and a greedy blogger who can't tell the truth if you paid him to.
They have sorry friends. Nope.
I'd like to comment. You know, Elisa Bennett.
I met him in I roughly, man lost his life.
No, I'm not going to comment on that, but I am going to comment on it. It's unacceptable for anybody to go looking to start a problem with them. They lost a family member. This ensuing service, they've been relentlessly harassed. Peggy O'Keefe has lost 2 children now. And there are lots of terrible things that people are making jokes about their losing children. Do you have no conscience? And, you know, in the beginning, I went from thinking she was innocent to realize that she was guilty of all the evidence showed itself. So I get why some of these people believe she was innocent, but to ignore the evidence because you're so engrossed in conspiracy theory and getting some sort of clout. That's a problem. These are critical thinking. These are common. They were aggressed. No, they were not. It's not that hard to figure out. She left him to die, whether she meant to or not. Irrelevant. She did. Yeah, I mean, I stream this every single day for my kids, for the family, for John, for anybody, right? Whether I've been relentlessly harassed myself on a daily basis, messages, phone calls, DM, texts, you name it, I get it. But I
Altercation with a young lady. What was that about?
your water on me.
Did she say she gets harassed? Isn't she the one that's...
Okay. So I was just wondering why anybody would think that was okay. But of course, you get no answers, right? So I'm not going to allow people to bully and then act like, oh, well, we didn't do it. Like, that's bullying. And I'm not okay with bullying. If you have something to say, cool, you have that.
I know she just didn't. I know she just didn't. This is one of my favorite quotes. Promote what you love instead of bashing what you hate. That's why I said earlier, if you believe in Karen Reed's innocence and you want to support that, support that. If you believe in Karen Reed's guilt and you want to go up there and, you know, show your support for the family, then show your support for the family. But neither side should be bashing the other. That's not what support is. That's looking for conflict. And from everything that we've heard about Officer O'Keefe, does it not seem like he's not the type that wants conflict and wants to be like everything that we heard about him is like the opposite of this. If I feel like if you're wanting to support Karen, then support Karen and leave everybody else alone. If you're wanting to support the O'Keefes and you believe that Karen is guilty, fine, support the O'Keefes or McCabe's or Alberts or whoever and leave everybody else alone. This is not support. This is not support. If something happened to me and I found out that this is how it was being handled, I'd be so mad. Because y'all know how I don't like conflict. I don't like arguing. I don't like ganging up on people and trying to cause conflict in the name of whatever the heck you're wanting to do it in the name of to excuse your shitty behavior. I don't like that. And if I knew that people were doing that and saying that it's in my name, I would be so upset. I would be so upset. And also, if you're against bullying, you probably shouldn't bully. I can't even watch it anymore. I don't want to. It's ridiculous. I feel like if you're concerned about, which we all should be, concerned about Officer O'Keefe getting lost in the circus, setting up another tent at that circus is not going to change that. Hi, Matthew Harris Law. The fan is less controversial. It's the only fan. I feel like if there were I don't know. This case has brought out the ugly in people, and it is just sad. I had no idea when I first started digging into this last year, I had no idea that it would get to this point. It is crazy. I don't even know what is going to happen when there's a verdict. I cannot imagine a hung jury because I can't imagine anybody having to go through this again, much less, you know, the O'Keefes and the niece and nephew and Karen's family. I don't. I don't get it. If this is a hung jury and they decide to try this case again, I don't even, the thought of that even just makes my stomach hurt. Either way, people are going to, like, there's no, we did a poll on it earlier if you thought that they would retry it if it was a hung jury. I hope it's not a hung jury. But either way, I mean, no matter what happens, it's going to be a disaster. It is still ongoing, so we don't know much about it yet, other than what's been in the documents that they filed. Since this started, I have never heard. Let me try that again. Sleep deprivation is getting to me. Since this started, I have never once heard the Free Care and Regroup say anything bad about John O'Keefe's family. There are like extremists on both sides who do and say things that they shouldn't do and say. It happens on both sides. There are extremists on both sides. Shauna West says, Brandy, thank you for the breakdown of this entire trial. Didn't know the journey I was taking when I started your podcast last week. Thank you. Thank you. I didn't know the journey that I was taking when I started making this podcast. Little did I know. If hung, how can they redo this case? Everyone knows about it. How can they pick a jury? I have no clue. They would have to move venues, I'm sure. I had to try it in Siberia. Thank you. Thank you. J-Rock says, I live in Mass in a different area, and there are free care and read signs on many lawns. Grumble Momskin, thank you for the super chat. I really do not understand. They think there is no reasonable doubt. The crash daddies alone. The crash daddies were for me, like, that's all the reasonable doubt I needed. But, I mean, not everybody sees it that way. Woman 406, thank you. You and RA are the only ones I watch trials with. You are amazing and beautiful inside and out. Thank you so much. RA is beautiful inside and out. He's my friend. Do you think the jury should have been sequestered? I don't know how long, like, I mean, with this being so long, I think it would be really hard to have them sequestered. And if the jury is any, like, if social media is any indication of how the jury is, if you sequester them, then there may be another trial after that. So I don't know if it's the best idea. Don't know if it's the best idea. The extremes just polarize further. That's the problem that I have seen with this trial, is the extremes get more and more polarized, and the reactionary behavior on both sides is difficult, because as much as you want, like, if y'all even knew, if you even knew behind the scenes, if you even knew, I had hoped to try to calm down some of the toxicity in this case. And so I reached out individually to different people on both sides who I felt like are aggressive, and tried to have those conversations like, hey, you know, if we can tone this down some, and we can, like, work together and have debates and snark and sass and passion and all those good things, but no vitriol, then think about how much easier this would be on everybody. And sometimes it went well, and sometimes it didn't, and sometimes I was completely ignored. Even when it went well, it was still like, you know, I'll do that. I appreciate that perspective. And then that ended within a couple hours, you know, but I mean, whatever, at least I tried. But I love a good snarky debate. Love it. Don't take it personally. Love those. I love it when you're passionate about something and you tell me why you're passionate about it. But when snark or passion turns to aggression and vitriol, that's no longer a debate. That's an argument. And I don't want any part of that. And so many people are so reactionary, and people don't want to debate. They want to attack and be right. And there's no sense of understanding in that. And that's really unfortunate. Can't we all just get along? Nope. Apparently not. Oh. Just hit 20 hours. This is apparently wrong. Oops. There. I fell asleep. Who is this blonde? Who's that blonde lady talking? What did I miss? Grumple Momskin, thank you for the gifted membership. Thank you, thank you. Thank you, thank you. I did hear, though, O'Keefe's had a problem with the free Karen people yesterday. True or not, I don't have a clue. I heard something about people in pink showed up at wherever they were. I don't know. I was working. That's all I heard. I just wish everybody could. I just wish things were different. Mermaid Mary Arian, thank you so much. Well, you know why I'm here. Love the healthy discussion, and the healthy discussion you facilitate, the way you keep an open mind and maintaining an even keel and covering this trial. Thank you. I don't feel even keel. I feel, where's my goat? That's how I feel. Matthew Harris Law, what matters most is the wonderful people here in your chat get along. Y'all are all fantastic. I love our chat. I love our chat. Natalie, get to the membership. Thank you so much, Natalie. Oh, thank you, thank you. What's the blonde lady story? I just, for whatever reason, everyone, we were laughing about the different things that like you see in chat all the time. And one of the things is when people are new to the channel, they'll, like, for whatever reason, they'll say like, who's the blonde lady on the screen talking? Like, Brandy. Hi. It's Brandy. Ryan Apple Snapple, member 10 whole months. Hope everyone is having a good day. The best. The best. I just share that. Court TV said that the injuries were indicative of a vehicle pedestrian strike. Are they watching the same trial? Crash daddies and all the medical examiners said the opposite, that without, because lack of bruising and stuff. I don't even know. I don't even know. I have never walked away from a trial each day and looked at social media and wondered how the trial that I watched is somehow the same as these other two groups and what they watched. I don't know. She did not say I'm not okay with bullying. Twisted Fire Sata, $20. Thank you so much. Thank you. Thank you. Same as I told RA when he started, never interject yourself in fighting. You will be seen as inciting or milking it. No matter your intention, take a step back, do your thing. There is no winning. There's no winning. Yeah. I've used my block button so much. So much. Dreamlander, get to the membership. Thank you so much. Thank you. Thank you. It's almost 3 there. Physics and stuff. This is worse than the Melly trial. I never did find my brows, but I've got to be on NBC tonight anyway. But I think that apparently I'm supposed to have some this weekend. Matthew Harris Law member for 14 whole months. 14 months is the gestation period for a giraffe. How long was April the giraffe pregnant for? Like 50, 11 years? Happy anniversary. Happy anniversary. Queen Oliver Than, get to the membership. Thank you so much. Thank you. Thank you. Thank you. Thank you. Twisted Fire Stata. I had to do it in that, like the song. I have to do it in the accent, like the song. Do you know about hide user from channel? It's lovely. Oh, yes. Oh, yes, I do. Oh, yes, I do. Sure do. Love that button. Learned that one pretty quick. Love that one. That's why our chat is so great. It's those internet streets out there that are different. Yeah, I'll be on NBC Boston at 7 tonight, 7 Eastern. And yeah, if you're not local, then you can watch it on NBC 10 Boston's YouTube, Canton Confidential. It'll be live on their YouTube, and they have a chat and stuff. Nancy D, thank you for gifting membership. Thank you, thank you. I'm behind on chat, but I'm trying to read some of what y'all are saying. I like to hear what y'all have to say. Or hear, read. Angelina, member for 10 whole months. Mods and chat, family, love you all. We love you. We love you. How many, if any, are you close to 26? Oh, I haven't looked. Hold on. Let me look. Oh, we hit 26K. Oh, that's cool. We're at 20. We just hit 25 a couple days ago. That's cool. Yay. Who knew? That's exciting. Right now it says 26,003. 3 to spare. Yay. It's the biscuit song. My biscuit brings all the subs to the yard. That's why I shouldn't stream when I'm sleep deprived. Look at us just a growing. I love how y'all use all my terms, my terminology. Definitely the biscuit song. It's totally. Shouldn't have said that out loud. That's going to be on clipped on the internets. I'm at the doctor. Anything happened since the deadlock? Just protesting and fighting outside, but nothing else. It's 3 o'clock. I don't know. We'll see. Little B, thank you for the super chat. Thank you, thank you, thank you. Thank you, thank you. Uvalde sheriff has been indicted on 10 counts. Nurse for God, hi. I wake up humming Taste of Biscuit. Congrats on 26K. You're the best. Thank you, thank you, thank you. It's that song gets in your head, doesn't it? It's hard to hard to get it out. Taste of it. Oh, It does get stuck in my head. Praying this doesn't go into it's. Oh, I think it's going into Monday because it's already almost 3. It's like right at 3. And I mean, I don't know how long they're keeping them today. Because if they come back, because even if they come back, what she's going to do next is read them the Allen charge, or what do they call it on this? Whatever they call it on this one. What do they call it on this one? I keep wanting to say Tui Rodriguez. Is that right? I can't remember now. I think it's Tui Rodriguez. Okay, yeah, Tui Rodriguez. So, I mean, it'll definitely go into next week. I was not expecting that. Yeah, the dynamite charge. They call it, in Massachusetts, they refer to as the Tui Rodriguez. And we pulled it up and read it a little while ago. So, I mean, it's definitely going into next week unless she keeps them there. Can I make them come back Saturday? I don't know. I'm not. I hope not. I'm not streaming tomorrow. Interview tonight is at 7 on NBC. All right. I'm going to let y'all fit. I need to keep working on the podcast episode. There's a few more minutes left on the that was the wrong button. Stop pressing buttons, Brandy, on the podcast. So I'll leave that on until, let's see if we can cover the see if I could get it to where you can see that the fan, see, this is the thing, is like everybody's very particular about how everything is set up. So I have to get it where it covers the spinning fan, but you can just barely see at the top that the fan is still moving, so that the movement's not bothering anybody, but you can still see that it's moving so that you don't panic and think that it's frozen. It's the goal. Hi, Mac. Thank you so much. Thank you. Thank you. Congrats on 26K subs. Follow your dreams and never give up. Thank you. Thank you. Thank you. That was not me pressing buttons that time. Thank you. Thank you. Okay. I am going to let you listen to more of the podcast while I work on this other episode. And then when they come back, we'll stop it and listen, and then Matthew Harris Law, I got to get back to suing people. I'll see you wonderful people later. Bye. 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 We'll see how the afternoon goes, but I've got to work on this more. I cannot be up all night again. All right. I will see y'all in a few minutes. I'm going to start this again. Of the State Police Detective Unit at Norfolk County District Attorney's Office called him to 34 Fairview the afternoon that John O'Keefe was killed. Tully told him that they were conducting a death investigation in Canton and they needed assistance with the search. O'Hara was able to respond, but it took him time due to the blizzard-like conditions. He was cleared for his team to respond around 3:45 that afternoon, and he told them to bring shovels and brooms and rakes, things that they could use to go through the snow. He and his team conducted a search in the front yard at Fairview for about an hour, and he says that they located 6 or 7 pieces of taillight and the missing shoe from Officer O'Keefe. Proctor was not on scene while the searches were being conducted, but defense asked about Proctor almost immediately during cross-examination. Yannetti also asked about the state police taking over the crime scene from Canton Police Department, who left the scene unattended for 6 to 7 hours before their search began. O'Hara said that he wasn't aware of it being left open, and he didn't know that Canton Police Department had been conflicted out of the investigation before he and his team arrived. He was asked to look for the missing shoe and pieces of taillight, but was never asked to look inside the home. By the time the search team arrived, it was around 5 and the sun had set, so the search was done in the dark using headlamps. He said they were able to uncover multiple pieces of red and clear taillight and the sneaker in the area between the flagpole and the fire hydrant. Some of it was found in snowdrifts. There wasn't any kind of mapping of the exact location that things were found, which Yannetti brought up when questioning about the integrity of the crime scene. But he said that the team did set up a grid search around where the car was believed to have been parked the night before. O'Hara said that after finding some of the taillight pieces, he asked to see a photo of the car to know how much of the taillight was broken and what they were looking for. But Tully told him that the car was being towed back to Canton Police Department, so he could not get a picture. The search ended around 6:15, but O'Hara told Tully that they could return the next day during daylight hours to search more. One of the important things that O'Hara brought up is the time of the first piece that they found at Fairview, which was around 5:45. Now, part of the defense's theory is that the taillight pieces are planted. So Karen's car was being brought to the Sallyport and first seen on video around 5:30. The CERT team arrived at Fairview at different times. One arrived at 5, one arrived at 5:15, 5:30, 5:45. So there are different times of arrival for the different team members, but the first piece was found at 5:45. We're going to get into depth into the timeline during Proctor's testimony, but I wanted to bring it up now because that was an important piece of information from this testimony. Maureen Hartnett also testified on day 19. She's a forensic scientist with the State Police Crime Lab. Now, we've heard this name a lot in pretrial hearings, specifically about the apparent hair. She is a scientist that defense said failed her proficiency exam. So they said that she was not qualified to identify the apparent hair found on Karen's car as a human hair. So Hartnett addresses this and said that she made an error identifying hair, which led her prior work to being examined and additional training. On February 1st, Hartnett reported to the Canton Police Department Sallyport to examine Karen Reed's SUV. She conducted an overall physical evaluation of the car for anything that could be reported for the investigation. And she said that the car was in overall good condition, but there was damage to the rear passenger side area. There was a small dent in the trunk door, scratches on the rear bumper, and of course the broken taillight. Now, Hartnett is also the one who saw the apparent hair on the rear quarter panel and some pieces of apparent glass on the bumper. Hartnett performed blood screening on the undercarriage of the vehicle, the bumper, and the tires, but it was negative. Now, this was interesting to me because I've always wondered about the scratches on John O'Keefe's arm. I remembered my interview with Dr. Kenneth Kinsey about how the prosecution would need to find a way to explain the injuries on John's arm and line them up with something else. I thought if they were able to do that with the underneath of the car, that it could make more sense that she hit him, but there was nothing found under the car. So that's ruled out. Hartnett collected the apparent hair and glass, as well as the taillight housing, several paint standards, the broken drinking glass found at the scene, and the red Solo cups with frozen red-brown stains inside. She examined the hair and believed it to be consistent with human hair with a root, but she said that she was unsure of which part of the body the hair came from. She performed tests on John's hoodie because she said that it had several red-brown stains in several areas, his t-shirt, his shoe, and test confirms that the stains on his shirt and shoe were blood. Now, I'm also hoping to hear more about this when the medical examiner testifies. For a drop of blood to be on his shoe and what we know from his injuries and how he was found, I need to understand how blood would have dropped or splattered on his shoe when the injuries were all to his arm and his head. I know that blood drips down to your shoe if you're standing, but I just don't know how to make sense of this from the Commonwealth's theory. Also, the holes and tears in John's sleeve seem to coincide with the injuries to his arm. These tears are where the swabs were taken to be sent for canine DNA testing. As for the Solo cups, she said that they were not labeled in any way, and she didn't actually test them at all. She said that she allowed the frozen red-brown stains to thaw and then took 2 swabs to be analyzed from an outside lab, but she took them from just one of the Solo cups because she just assumed that they were all related. No DNA testing was ever done on the blood swab. Similarly, she only took 1 swab from the taillight housing, noting that it was, quote, all one swab, one detection, end quote. Another question was about this apparent hair that she found. It wasn't attached to the car in any way. It was just kind of on the car. Now, on cross-examination, Alan Jackson pointed out that the car would have made a 60-mile trip in the middle of a blizzard with this apparent hair stuck without somehow coming off, and the pieces of glass that were found on the bumper would have made this 60-mile trip and somehow not have been blown off. It seems unlikely when this is said out loud, but I'm not an expert. The jury will have to decide what they think. I want to skip ahead to the testimony of the results of all of this testing. It doesn't come for a couple days later in the trial, but I just want to go ahead and get this part out of the way. The hair was, of course, tested at the Massachusetts State Police Crime Lab, and no human DNA was detected. It was sent for mitochondrial DNA testing at Bodie Labs, and their testing showed a match to John O'Keefe. The DNA from the taillight was confirmed to be John O'Keefe, but also showed the DNA of 2 other individuals who are unknown and unrelated, though Proctor and Buchanan were ruled out as contributors. I think that if the taillight DNA had been only John's and not a mix of multiple people, or if it had been from blood or tissue, I think that it would have had more of an impact to me or to the jury, but it isn't quite the proverbial smoking gun. The stains that were tested on John's clothing and shoe were a match for his blood. No surprise there. And the DNA profile on the drinking glass matched John as well. And no surprise there either. We saw him leave with it in his hand on that video. So what were they able to do with those taillight pieces? We'll go over that right after this. So the jury heard about the taillight pieces that were collected, as well as the glass fragments, and about them being put back together and how they were able to match things up. Analysts worked to reconstruct the taillight out of the pieces that were collected. They taped it together and then showed how it could all have come from the same piece. Now, a lot of this testimony is really technical stuff about procedures and analysis, and then having to go through each of the pieces and which pieces came on what day and from what search and was signed by who. And I noticed that some of the reporters in the room had commented on how the jury had kind of looked away and weren't as engaged as they normally are. And I can understand why this testimony took a really long time. So the perk of getting to listen in the podcast is that we get to skip all of that and I can get right to the point. Ashley Valier is a trace analyst in the Massachusetts State Police Crime Lab. She performed what she called physical match analysis on bits of apparent red and clear plastic in the debris from Officer John O'Keefe's clothing. including his jeans, boxers, hoodie, and t-shirt, and said that she noted apparent dirt debris. There was also a straw, plastic, and glass. But on cross-examination, Yannetti questions Valier about her analysis, and we hear that she didn't actually examine John's clothing directly. She examined the debris from his shirt. In that debris, she found pieces of red and clear plastic that she then sent on to another analyst for further examination. So we've been hearing for a while now that microscopic taillight pieces were found embedded in John O'Keefe's clothing. I was expecting to hear a little more about this, but Valier said that it was given to her for analysis as a separate item, specifically labeled as the debris. There wasn't an actual shirt in there that she was digging these pieces out of. So part of the defense's theory is that the taillight pieces were planted, but we heard about these microscopic pieces. So I was expecting testimony about how they were actually embedded in the fabric of the shirt. But instead, Valier said that they came in the package that was separated into 3 categories. One was dirt and debris. One was several apparent hairs, which were never tested. And the third was the pieces of the apparent plastic, which measured approximately 1/8 of an inch by 1/16 of an inch. Now, she said that she doesn't know what the person who packaged it did to collect that. Valier had no control over how the evidence was handled before it came into her possession. And she says that they have a chain of custody in the lab, but she didn't follow the evidence as it went through the chain. Yannetti asks her which trooper delivered the items to her. And this was the response.
Well, which state trooper delivered the pieces of red and clear plastic pieces, I should say, that you just testified about?
The item 7-5 to 7-19.
Right. The several pieces of red apparent plastic and one piece of clear apparent plastic measuring 1/8 of an inch by 1/16 of an inch. That's what I'm referring to.
Wait, sorry, could you repeat the question?
Yes. You understand what I'm talking about, right? In terms of the several pieces of red apparent plastic and then the one piece of clear plastic that you have the measurements for?
You're talking about the apparent plastic that I noted in the debris of 7-18.18?
Correct. Which state trooper was it that delivered that?
Do you know?
Sorry, that's an odd question.
I don't know if you want her to repeat it, Ms. Giannetti. Go ahead. You have to repeat that, please.
So evidence is submitted to
what you just said that he missed.
Oh, I said that's kind of an odd question.
Oh, not for me.
So.
Do you have a record of that?
A record of what?
A record of which state trooper delivered that debris to the lab?
So it wouldn't be delivered as like debris. It would be delivered as the individual piece of clothing, which then got assigned item 7-18, I believe. And then as someone analyzes it, each offshoot of that piece of evidence gets a 7-18 point something. So the debris collected from that shirt is 7-18.18.
Okay, all right. Listen, when those several, actually, let me strike that. Get to where I was.
Take your time, Ms. Giannetti.
Okay, so I want to confirm with you that when you were assigned to this case, you were aware that the date of the incident was January 29th of 2022, correct?
Yes.
All right. And it's your testimony that you don't know which state trooper delivered the shirts to the lab, correct?
I could look at my notes because I have a printed chain of custody.
Sure. If you would check your notes for that, please.
Okay. So. Okay, so submission 7, which is everything that's item 7 dash in this case, was submitted by Trooper Michael Proctor, I believe.
Oh, that was the answer to my
Okay.
other question. Thank you.
So Proctor brought in the clothing, and someone else at the lab separated the dirt and debris, apparent hairs, and plastic, and then she analyzed it. But the pieces were not actually embedded in the clothing. The note says that Proctor dropped the clothing off on March 14th, 2022, which was about 6 weeks after John O'Keefe's death. There were a few interesting things that came up during cross-examination that could potentially support the defense's theory and show reasonable doubt. One, the pieces submitted to the lab by Proctor were larger than the pieces found by other troopers. Now, you would think that the initial search would have found the bigger pieces, and the searches after would have found the smaller, harder to find ones. It doesn't necessarily mean anything, but it could show the jury that taillight pieces were found later that are bigger, could have been possibly planted. The other thing is that when they put the taillight back together, it was missing a piece that was never found. This could also potentially support the defense's theory. So if Karen did in fact crack her taillight when she backed into John O'Keefe's car, could that piece that's missing have fallen inward during the impact, back in toward the taillight housing? Carrie Roberts testified that she saw a small piece missing, and Officer Nicholas Barros, who testified on day 22, said that when he went to Karen Reed's parents' house at the time that the tow truck was going to get the car from the driveway, the taillight, he said, was not completely damaged. It was cracked and a piece was missing, but he said it was not completely damaged.
I saw that there was some damage to the right rear taillight. To my best ability and recollection, that taillight was not completely damaged. It was cracked and a piece was missing, but not completely damaged.
Of course, the photos that we saw later from the Sally Port show that taillight completely damaged. So it's hard to say. It seems like this could definitely be interpreted either way by jurors. It's just going to depend on what they believe. The other really interesting part is that the glass that was found was analyzed by Christina Hanley, along with some other things. So some of the glass was able to be fit together, and there were 4 items that Christina analyzed, though she put some into subcategories and labeled them to keep track. So the first was a single item, like just a cup. The second was the bumper that had 5 subcategories. And the third was multiple pieces of clear apparent glass and multiple pieces of plastic. And the final was a single piece of glass from Proctor. So here's what's interesting. She was able to match up some of this plastic and glass, but the only thing that the glass on the bumper was consistent with was the one piece that Proctor turned in. And the piece that Proctor turned in was only a match to the glass on the bumper. So where did this glass come from, and how come it doesn't match the single item cup piece or pieces? Why are we almost to the end of the Commonwealth's case and we still have questions? How are we still finding doubt? The next 2 episodes are going to be packed. There's a lot of information to get in. There's going to be some explosive texts from Proctor. You don't want to miss that, but you might not want to listen with your kids in the room. The cell tower data from Karen Reed the morning that she left to go find John. Did she go back to Fairview like we thought she may have? And the data from her car. Is the Commonwealth finally about to put their case together for the jury? Will they be able to close the gap of reasonable doubt? Or has too much damage been done already? Are we any closer to justice for Officer John O'Keefe? We'll find out next time. My name is Brandy Churchwell, creator of 13th Juror Podcast. If you're enjoying it, please leave us a review on Apple Podcasts and Spotify, and share this episode with your friends. For more information, photos, and episode guides, Visit our website at 13thjurorpodcast.com.
The trial of Karen Reed for the death of her boyfriend, John O'Keefe, is underway.
There are 17 jurors, and they are coming and going with a police escort.
I've seen a lot of things. I've never seen anything like this. This case never ceases to amaze me.
The first week of testimony has come to an end.
It's a spectacle, that's for sure.
We really heard the defense highlight some of the discrepancies between what was documented and what first responders said they remember.
There are a lot of issues in this case.
Proctor was improperly searching Karen Reed's cell phone for nude photos.
The fact that the investigation wasn't thorough provides a big wrinkle in the prosecution's case.
They're supposed to be creating this reasonable doubt, and they're doing exactly that.
Everybody wants to know, us included, why he wouldn't go inside that home on the night that the body was discovered.
There are more people here at the beginning of this than at the beginning of Johnny Depp's trial.
It's always the theories or stories that each side will put forth, right, for a jury to listen to and decide which one is more believable.
We asked Karen Reed about that alleged confession. Karen, did you ever say I hit him?
I did not.
The FBI is investigating an investigation of a murder. That never, ever happens.
Karen Reed was drunk and angry and hit and killed John O'Keefe when she gunned it in the snowstorm.
We're looking at arm injuries with scratches. We're not looking at tire tracks.
I did not kill John O'Keefe. I've never harmed a hair on John O'Keefe's head.
Defense attorneys learned in school, first class, the most important thing you can do is identify and select stupid juries.
We're not concerned about any of the witnesses. None of the Commonwealth's witnesses are concerning us.
Karen Reed is facing up to life in prison.
I just hope justice is served for either one, whatever it is, you know.
The fate of her life is not in her hands anymore. It's not in the hands of her attorneys. It's not in the hands of the prosecutor. It's in the hands of the jury now.
Free Karen Reed! Free Karen Reed! Free Karen Reed! Free Karen Reed!
The trial of Karen Reed is moving along. We now have heard from more than 50 witnesses over the course of 6 weeks. Names that we've heard over and over, names that are crucial to understanding the theories of what happened, are finally being called by the Commonwealth of Massachusetts to give testimony into what they may know about the death of Officer John O'Keefe. We are finally getting to hear from some of the experts, some of the state police, John's niece and nephew, and some of the Canton public workers. But before all of that, one of the most anticipated witnesses took the stand on day 17 and 18. We finally heard from Brian Higgins. Higgins is one of the names that we have heard repeatedly. He was present that night at Waterfall and at 34 Fairview. He and Karen shared flirty texts over the course of a couple of weeks when things got rocky with John. And we've heard all about him getting rid of his phone on a military base around the time that the phone preservation orders were signed by the court. I don't know exactly what I was expecting with Higgins, but whatever it was, I don't think that what I was expecting was what we got. I'm not going to spend too much time going over Higgins' background because I've introduced this in a previous episode, but I want to point out that he does have an extensive background in law enforcement, military, and as a firefighter and first responder. After the tragic death of his sister, Canton Police Chief Berkowitz offered Higgins a space at the Canton Police Department to use as an office, though he was actually an ATF agent. During cross-examination, attorney Alan Jackson points out that Higgins has full access to Canton Police Department solely based on his friendship and relationship with Chief Berkowitz. Jackson says that Higgins' closest friends are some of the most powerful people in Canton in terms of politics and law enforcement. He even brings up a toast that Higgins made at Berkowitz's retirement party, where Higgins says, quote, "If you want to hide a body, Ken Berkowitz is your man," end quote. Higgins, Brian Albert, Kevin Albert, and Eddie Hernandez all rode back to Massachusetts from New York together after the funeral of the New York City officer that they attended that January in 2022. Alan Jackson brings up a fist fight at a Christmas party between Brian Albert and Eddie Hernandez, but the objections were sustained, so we didn't hear much detail on this altercation. Jackson wants to use this as an example of what he refers to as a reputation that Brian Albert has for being a fighter. And he also points out that Higgins testified to the federal grand jury that even Chief Berkowitz was a little afraid of Brian Albert. Higgins took Brian and Eddie to get their cars when they got back from New York, and then he dropped off Kevin Albert. He swapped from the truck that he was driving over to his Jeep that's equipped with a plow, and then he went to Hillside to meet Brian Albert and get some food and drinks. The swapping of cars, as well as how many cars Higgins has, is brought up a couple of times. He has a government truck, a surveillance vehicle, and he flips between his personal Jeep and truck. Some of these cars that he keeps are at Canton Police Department, and he leaves an available key if they need to be moved to, for example, plow the parking lot if it snows. While at Hillside, Brian Higgins was drinking Jameson and ginger. That's his drink. And Brian Albert told him that he was going to be going to Waterfall to meet up with his family and friends. So he invited Higgins to come along. Higgins estimated that they were at Hillside for an hour or so, and he said that Brian Albert left about 15 minutes before he did. He estimated that he arrived to Waterfall around 9 p.m. Higgins describes his relationship with Brian Albert about the same way that Brian Albert described it. They were co-workers, but they've gotten closer in recent years, becoming friends and hanging out socially. While at Waterfall, Higgins said that he saw the defendant and John O'Keefe walk in. And Higgins actually referred to Karen as the defendant, which was interesting given the familiarity between them. I've mentioned before, referring to someone as the defendant is a way to take the emotion out of it, since it's easier for a jury to convict a nameless defendant than it is for them to convict a person with a name and friends and a family. Higgins didn't talk to Karen while she was at the Waterfall, but he said that when he left, he sent her a text that said, well, and referred to this as a flirty text. We're going to get into the flirty text more in a minute, but it gets awkward and I'm not ready to jump into that nonsense just yet. Higgins said that Brian Albert invited everyone to go back to his house, so he said he decided to go. I was very interested to hear what Higgins had to say about where he parked his Jeep. This has been one of the issues that we've had with so many of the witnesses' conflicting statements. Where did Higgins park? He says that when he got to Fairview, he was being a quote-unquote smartass and decided to use his plow to do a sweep of the driveway, though the snow wasn't really accumulating yet. After he pulled in the driveway and did this, he said that he pulled out and he parked in front of the mailbox with the rear of his Jeep backed up to the edge of the driveway. Now, this is the same spot that Matt and Jen McCabe said that they saw his Jeep, but also, it's the same spot that everyone else who pulled up in that truck said that was definitely empty. I don't know. I'm still not quite sure what to make of that. I don't know how some people can be so sure that the Jeep was there and other people can be so sure that it wasn't. Higgins went in the side door and he said that he hung out for a while, but he didn't stay long because all they had to drink was beer and he's a whiskey guy. He looked at pictures with Brian Albert of his son, who was in the Marines, since Higgins and Brian Albert also both served in the Marine Corps. But he said that they were only in the other room briefly. Higgins contradicted Brian Albert's testimony that they went upstairs to look at pictures in his son's room, though. He said that he had never been upstairs at any time in Brian Albert's home. He also said that he never went to the basement that day, but he had been in the basement before. There was a moment during cross-examination where Alan Jackson brought up Brian Albert saying that he and Higgins walked, quote unquote, upstairs. And Jackson was trying to ask Higgins, if you've never been to the third floor of their house, but y'all walked upstairs, that would mean that the testimony about walking upstairs would have put you in the basement, walking upstairs back to the main floor. But Higgins doesn't really pick up what Jackson is trying to ask, and Jackson is limited on the form of how he can ask it. So he never really is able to get the answer out of Higgins that he wants, but I think that the jury understood where he was going with it. Something that was pretty major that came up during cross-examination is the description that Higgins had given of a male who apparently entered 34 Fairview after they returned there from the bar. Now, we've heard pretty much the same story with some varying or conflicting details from each witness, but the overall story has been mostly the same, at least about who was at the house. But this is the first that we've heard about a tall, dark-haired male entering the house.
Now, you do recall giving testimony at another proceeding on June 1st, 2023, correct?
Yes.
And of course, the same thing applied. You were under oath. Is that right?
Yes.
You knew that it was a crime to lie under oath
Yes.
in that proceeding. During the course of that proceeding, you were asked who was in the house and who you saw come into the house, correct?
Yes.
And during the course of that testimony, you admitted that you observed a tall, dark-haired male enter the Albert house that night, correct?
I believe that was in reference to ask it to somebody's brother in a pickup. I don't know if that was during.
All I'm asking you, Mr. Higgins, is did you say that? Did you say a tall, dark-haired male entered the house while you were there?
I said they might have.
Did you say they might have?
Yes.
Higgins testified that he wasn't really paying close attention, but there was a tall male that he didn't know who entered the house briefly. Jackson asked about him giving this statement to the Massachusetts State Police, but Higgins said he doesn't recall. And he also didn't mention this person to Lally when he was asked about who was in the house. The first thought that I had would be Julie Nagel's brother, but he never entered the house, and he's not a tall, dark-haired man. John O'Keefe is tall, but Higgins knows him. Colin Albert was tall, and Higgins said that he didn't think that he would be able to pick Colin out of a lineup. So maybe Colin? It's another question that we're left with. Higgins said that he never saw John or Karen enter the house, but he said that he did send a text to John while he was at the house asking where John was or if he was coming. Higgins said that he was actually the first person to leave the house, and while he doesn't remember specifically what Colin looked like, he said that he never saw him. We know from testimony that Higgins actually arrived before everyone else. Remember that whole sweep the driveway thing? And we know that Caitlin, Nicole, and Brian Albert all saw Colin, but somehow Higgins said he didn't. He didn't stay long, he said. Remember, they only had beer. And when he left, he said that he went out the breezeway or the middle door. He said that he got in his Jeep and moved just a few feet, but he heard the plow grinding. So he lifted it up about a foot or two and then drove away. He doesn't remember seeing anything that concerned him. No tire tracks and definitely no body in the yard right in front of where he parked or where he drove by to leave. Higgins said that when he left, he knew that he had to go by Canton Police Department to move the cars before the snow came so that the parking lot could be plowed. Otherwise, he said he would have to wake up really early to go do it the next morning. He has a key card to get into the Canton Police Department, so he parks in the back and he cuts through the Sally Port to get to the station. Now, this is a Sally Port that we're going to hear a lot about in the next episode or two, or three. Higgins describes it as pretty small, maybe 12 feet long, to get from one side where he enters the door to the other side. Dispatch is off to the right side. There's like a wooden door with glass panels, and he saw Sergeant Good when he went in. Now, Higgins said that he went up to his office, he got the keys for the cars, and went downstairs and moved 2 cars to the center of the parking lot. And then he left Canton Police Department in his Jeep to go back to his home in West Roxbury. He estimated getting home around 1:30 or 2. We know it couldn't have been 1:30 because that's what time he got to Canton Police Department. He ate some food, he put his phones on the bedside table, and he went to sleep. Higgins said that he woke up the next morning to his phone blowing up around 6:30 a.m. First was a call from Chief Berkowitz, which he said he didn't answer, and the next call was from Brian Albert. Higgins said he did not talk to Brian Albert any time between when he left his house and that first early morning phone call. He denies those conversations at 2:22 a.m. More butt dials, which, of course, was addressed on cross-examination.
Your testimony previously was at some point before 7 a.m., that call was the one that woke you up.
Yes.
And it turns out, Mr. Higgins, that that was a lie, wasn't it?
No, it wasn't a lie.
When you were asked that question at a previous hearing, you didn't know that the person questioning you had your phone records, did you?
I assume they did.
And you were thereafter confronted with those phone records, correct?
I was asked about them, yes.
And those phone records established that you and Brian Albert actually exchanged not one, but two phone calls at 2:22 a.m. that morning, at a time when you claimed you were in bed asleep, correct?
I have no recollection of any phone calls.
These were the records that were shown to you at a prior hearing.
Yes,
And you acknowledge that at least the one marked QQ is a record of your calls, correct?
it has my name, my telephone number, correct.
And it indicates that on January 29th, 2022, at 2:22 and 35 seconds, you received a call from Brian Albert, duration of 1 second, correct?
Yes,
In other words, Brian Albert called you at 2:22 and 35 seconds, but it looks like you missed the call, correct?
I see the 1 second call, yes.
There's a second call just below that on the same date at 2:22 and 52 seconds from you to Brian Albert. Do you see that one?
Yes,
And the duration of that call is 22 seconds, correct?
I see that, yes.
So 17 seconds after you missed a call, according to these records, from Brian Albert, you called him back, and there was a call lasting 22 seconds. Is that right?
That's what the records say.
May I approach?
Yes.
So the fact is, you were speaking to Brian Albert in the middle of the night, approximately 3 hours before Mr. O'Keefe's body was found in his yard, correct?
No, that's not correct.
And that was 5 minutes before 2:27 a.m. when there was a Google search for how long to die in the cold, correct?
Objection.
Sustained.
And then, of course, you lied about that under oath in that prior proceeding by saying, I don't remember this phone call.
Objection.
Sustained.
Did you, in fact, tell the truth at the prior proceeding when you said, I don't remember that phone call?
I always tell the truth.
Did you lie under oath, sir?
No, I did not.
Would you tell us if you did?
Objection, Your Honor.
Sustained.
Higgins says that he doesn't think that 22 seconds is long enough to have a conversation of substance with anyone. But he also has a possible explanation.
Now, when you were asked about this and you were shown these records, that prior hearing, you had an explanation for what that 22-second call may have been and what the prior call may have been, correct?
Yes.
What was your explanation?
Well, I used a phrase that people commonly used as a butt dial.
So you think it's possible that you may have butt dialed Brian Albert for a 22-second call that you're not aware of?
I think it's possible that he could have been inadvertently called back, but I have no recollection of that, nor did I have any conversation with anybody.
How are we back here with more butt dials in this trial? I still don't understand. Jackson goes through some of the same line of questioning with these butt dials as he has with all of the others, having to unlock the phone with facial recognition or a passcode, dial a number or choose a contact or a recent call, etc., etc. And he verifies that Higgins lived alone. He has Higgins read his previous grand jury testimony that says that when he got the call from Brian Albert, he called him back. And it's possible that the phone picked up on the other end and Higgins terminated the call, which this is, of course, different than what he's testifying to today. Higgins says, regardless, there was no conversation with Brian Albert at 2:22 a.m. Higgins said that he went to Brian Albert's house that next morning after getting that call. He can't remember where he parked or how many police cars were there or anything like that, but he said that he does remember seeing Brian and Nicole and Jen and Matt, plus Brian Jr. popping in at some point and Julie Albert stopping by with donuts. Higgins said that when he heard about John O'Keefe being found on the lawn, that didn't make sense to him because he said that John and the defendant never showed up. Higgins said that he didn't stay at Fairview long, maybe less than an hour, and he can't remember if he went to the police station or back home after that. He was still upset and trying to put things together, and he said that he knows he was at the police station at some point that day, but he just can't remember when. Jackson says based on the key card swipes, records indicate that Higgins was at Canton Police Department from around 9 a.m. until 5 p.m., closer to 6. And we hear about key card swipes throughout the day. There's also a 12-minute phone call between Higgins and Kevin Albert from Canton Police Department. Jackson asks Higgins if Kevin was providing him with information about the death of Officer O'Keefe, or if Higgins was providing information to Kevin that he was.
You are unmuted.
Thank you, BC, sir.
All right, so I sent the note in at 3:30 like I've done each day, asking if they want to go home or continue. They indicated that they want to continue until 4:15. So we will continue until 4:15. Madam Court Reporter, thank you. Okay. All right, so I'll see you at 4:15.
All rise. Let's stand. Recess.
Maybe that's a good thing.
You are muted.
That's only 30 minutes. So maybe they're close. Otherwise, maybe. I mean, I feel like if they weren't close at all, they wouldn't want another 30 minutes. Right? Maybe. I did not get, I've got so much to do. Oh. Oh, wow. Georgia Born, get to 20 memberships. Wow. Thank you so much. Thank you. Thank you. Welcome to our new members. That says to me we are working on the, yeah, they're staying until 4:15. So some of y'all think maybe they're working on the verdict form. Maybe. I mean, it's late on a Friday. They've wanted to leave the last couple days. You need a member of staff maybe helping with the load. I don't have a staff. I have amazing volunteers that mod. If I could afford a staff, I would. Get to work, Lucy. She's fired. You see how productive she is all day. Get that blonde lady in the box to help. Right? She is a freeloader. Spoiled little furry freeloader. Dia said, thank you for the super chat. Thank you, or super sticker. Super sticker. Thank you, thank you. She said that the jury said that they wanted to stay till 4:15. Don't abuse that baby. She's useless. Lucy was modding chat while I was away. She did hold down the fort while I was on my Zoom call yesterday. So there's that. I wouldn't pay that blonde lady. She can't even find her eyebrows. I don't blame you. Little B, thank you for super chat. Thank you for staff help. Thank you. Kitty Kate, thank you for super chat. How did you get started in streaming and podcast? I just started doing it. I all of a sudden had a big following during Murdoch trial because I was making charts. And then people kept saying I needed to make a YouTube, and Distant told me I need to make a YouTube. So I made a YouTube and started doing like video recaps and stuff. And then Recovery Addict asked me to come on his live, and I was like, oh no, I can't do live. I can't do live. So I ghosted him because I thought I could never be on a live stream. And look how that turned out. And then with the podcast, I was like, I love listening to them. I've always wanted to make one. That was what I want. Like YouTube was never my main, like, oh, I want to do that. I like writing and telling the story. And so the podcast is always what I wanted to do. So I did it. And it took off. Big. Put my nanny to work. I love my nanny. Lally might be looking for a job soon. I'll get more use out of Lucy. CJ's mom, 55, member for 1 whole year. Yay, 1 year anniversary. Thank you, Brandy. You are awesome. Thank you, mods, chat. You are wonderful. P.S. Thank you, Law and Crime, for losing audio during the Travis trial. Right? It's how our little family grew a lot. I love it. Sandra, thank you for the super chat. Imagine they come back not guilty. We will have witnessed Lally's last mistake. Oh. He's not easy to listen to. He's really not. He's really not. The court had a hearing today for Sarah Boone, and they are granting her the motion to withdraw from her 8th attorney. Insane. Are you going to cover the Koberger trial next year? Yes. I have some stuff in the works on that I'm not ready to announce yet. I did. I ghosted RA because I told him I couldn't be. I was like, I can't be on a live. It's like I do recorded videos and charts. I can't be on a live. I don't have the personality for live. Okay, what do you think is going to happen at 4:15? Verdict or go home? Look, if Boone goes pro se, y'all know I'll be there in person. think we'll miss that. Please cover Sarah Boone. I will definitely be covering it in some capacity, whether it's recaps or going to the trial and then streaming recaps at night or something. I will be covering it in some capacity. But I don't know about the streaming live deal, but RA will be, I'm sure. What is her case about? She zipped her boyfriend in a suitcase and he died. He's done, see, so RA has done a lot of coverage on Sarah Boone, so I'm sure he'll be streaming it live. I believe I think I'm going to be there in person. And she filmed it, yeah, of him asking for help. It's all because of no official verdict eyebrows. Apparently, I'm supposed to have some in the mail tomorrow. Yeah, Ari's got all the unhinged letters on the channel. Kelly, thank you for super chat. My bestie had no idea about it. The case the past few days we were together. I'm addicted, but kept confusing her, so I made her listen to your podcast. It explains so simply, and now she's addicted. Yay! Thank you for listening to it. It's. I don't know if it's a good addiction or a bad addiction. Any chance that we can convince you to cover a case live again? I mean, I will, like some of the big ones I may do, you know, live again. It's just, it's hard because with the podcast, I can't, I don't have, there's just not enough hours in the day. I am not okay. I don't get enough sleep. It's too much. And I love hanging out with y'all. So I'm still going to stream, but the live trials during the day are too much. There's some big stuff happening with the podcast, and I can't do both full time. I'm literally working 2 full-time jobs right now doing this. And it's a lot. Oops. 2 little eyebrows too late. I never heard her say anything about deliberating on the weekends, but I doubt she's going to want them to. because I don't think she wants to. They have to be bussed in and all that. 6 whole months, Judy Haley, 6 whole months. Love it here. So happy to be a part of this family. We are happy to have you. We are happy to have you. See, I like the speed trialing too. The speed trialing is great because we get to spend time together, watch trials, see all the good stuff, and then not have to sit there through all of the what if anythings. Yes, we hit 26,000 today. Isn't that crazy? Very exciting. I like your condensed version of trials, and you need to do what is best for you. But honestly, I like the defluff fast version. I like the defluff fast version too. I love speed trialing. I love speed trialing. So I'm not only going to do podcast. I'm still going to stream. I'm not going to do the all day long 8-hour streams. I'm like on the trials that we do, we'll do the speed trials so that we're like getting all of the important stuff. But then, I'm not sitting here trying to entertain you for an hour while during lunch while you look at me like I'm a crazy person. So we get like all of the speed trialing is great because you can get like all of the full day condensed down to half the time. And then that way I can do the podcast but still stream. Because I enjoy doing both. I love the zoom of the speed trialing too. You can like just 5-second that little space bar. Oh, it just gives my heart joy. Sidebar, nope, no thank you. Speed through it. I love it. I love it. Oh, good. I can balance my time between you and RA. I've neglected that channel for weeks. It's funny because during the Maya trial, we had, because so many people split back and forth, but then when there's like the trials that you like really get into, especially the longer ones, that you really get into, then you tend to not be back and forth as much. You get suckered into one, right? And so the Maya trial was one of those, it lasted 11 years. And everybody who normally goes back and forth was just watching the Maya trial. And I didn't cover it. So it was like nobody, like, I didn't have any idea what was going on in it. So nobody wanted to talk to me about it because obviously I have nothing. I don't have any input. I don't have any. So then people were like, you didn't even watch it? Okay, I'll see you later. I was like, I'm sorry. I won't watch it. It was I think that was the lowest viewership that we had any other time since right after I started, like, was during the Maya trial, because I was like, I'm not covering it. Kelly Work says, so here's how I found you. Verdict Watch that has now led me wanting to hear all your podcast, and then Verdict Watch with us. Yes. Yeah, a lot of people did Maya live, and then we had our replay crew was higher during Maya than it ever has been before. Like replay numbers during that trial were huge. And then I love our replay crew would, come in and comment like, hey, I've been caught up with Maya, but I've, but I'm here. Our replays on those, whatever, I can't even remember what we streamed at that time. Replays were higher during the Maya trial than they've ever been on any other trial. On whatever we were covering during that time. But I know what that's like. Like when you get into a trial, like you have to know what's happening as soon as it's happening. Law, where did that message just go? It moved. Gosh dang it. Everything moves. Oh, I found you from Ashley Mary on Instagram. I saw that she was showing my stuff. That was really nice. That was awesome. Law and Lumber did a fantastic job with Maya. He is so sensitive and so smart and of course so cute. You know what's funny? I got an email about maybe a week or so ago. Well, not an email. It's like one of the comments on it sends me an email, but it's like where you can leave a comment on the website. It'll send me an email to let me know there's a comment. And I don't know which website it was because there's 3 of them. But whatever website it was, somebody left me a comment asking if Rob from Law and Lumber and I are married. No clue why. We've never done a panel together. We've never, we follow each other on Twitter, but I have no idea where it came from. And I was like, we don't even doesn't he live? I don't even know where he lives. He lives in another state, doesn't he? I don't even, but I thought that was the most random thing. And then somebody else in chat, in Glairer's chat, asked Glairer if I was his girlfriend or something in the chat. And then there was somebody else. And I was like, internet is just trying to pawn me off on somebody. Like, I don't know why. Internet is trying to pawn me off. It's the most random thing. See, I see how rumors get started. No idea. No idea how that started. He's engaged to a woman he met who is also a streamer. So maybe that's why. Maybe because I'm a female streamer. I have no idea. I have no idea. No clue. He'll just try to pawn me off on other streamers. So random. True crime rate. Are these our Marine Law stats? Final stats. Witnesses 74. 277 sidebars. That's a whole lot of sidebars in this trial. 1,347 objections. And 1,935 what if any's. That's crazy, right? Only a few more minutes. Yep, and he got engaged in Florida. People think there's 10 streamers. Oh, Rob did? Maybe that's why. Maybe he's engaged to a streamer and it happened in Florida, and that was, I have no idea. I mean, like, there's been a few posts on Twitter that I've retweeted of his or something. But I thought that was the most random thing, but maybe that's why. I don't know. And I don't know how the Glare one started. I don't know how. I don't know. People, like I said, people just try to palm me off on people. Can't miss. Can't. So random. I thought you were going to say I'm a female stripper, a female streamer. Two different things, usually. Maybe sometimes not so much, but usually. That's how rumors get started. I see camera movement. See what I mean? See what I mean? Everybody trying to palm me off. Although, like, professionally, could you imagine, like, my charts and his skills with the, like, graphics and stuff? Y'all crack me up. Breezy, thank you for the super chat. Not as many sidebars as Melly. Take a shot, do a spot. There were so many in that one. So many in that one. I think I'm going to stop this because I think they're back in the courtroom. Has Rob been rehomed? Wrong streamer. See, now that would be a professional match. Like, his videos and graphics and my timelines and charts. Fire alarm getting some love. I am ending the poll. I think they're going to send us home. Nervously eating chips and salsa. I used to judge and jury are in there. They're about to send him home. I used to do pizza every single Friday night too. Fan is inverted.
Closing session, please be seated.
So jurors, we all know how hard you've been working. It's been a long day. We're going to let you go home. We'll see you Monday morning at 9 o'clock. To the extent that you can, please just not think about this case this weekend. Clear your heads. We'll start fresh on Monday. So please follow those instructions. Do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it. We'll see you later. Thank you.
All rise to the court, please. Jurors, follow me.
No verdict. Sending him home. Coming back Monday.
Thank you. Be seated. Court is still in session.
All right. We'll see you Monday morning. Thank you.
Thank you, Your Honor.
Gosh. You couldn't hear that? You could barely hear anything. She didn't talk into the microphone, so but she said for them to go home and try not to think about the case as much as possible. We'll be back Monday. All right. I have so much to get done. So I am going to end this. If you are around this afternoon / evening, 7 o'clock Eastern, it's about 2.5 hours from now, I'm going to be on NBC Boston on Canton Confidential. So you can pop in there. They do great recaps, talk about the case. And I'm going to be on there talking about this and talking about the why people are so into this emotionally. So that'll be at 7, and then I will have the new episode. I have to have it out tomorrow. If I guess it's going to be another all-nighter. I have to have it out tomorrow, so it'll be out tomorrow at some point. Episode 20. And I guess we're going to be back on Monday. So Canton Confidential tonight. It's 7 Eastern. And new podcast episode tomorrow. And be back on Monday. Bright-eyed and bushy-tailed. I'm sleeping all day Sunday. All day. All right, y'all. I appreciate it. Thank you so much. Mods, thank you for everything. Thank you for hanging out today. Going through all of our whatever the heck it is we went through today. I wonder if Canton will have more public fights over the weekend. Yep. It ain't going to end anytime soon. There will be more fighting, more internet drama, more bullying, more craziness. And all we can do is stay away from it. Hit the like button on your way out if you haven't. Thank you for reminding me to say that because you know I forget. Oh, is RA still live? Yeah, we can redirect over to him. We'll redirect to RA so you can listen to Sarah Boone. Crazy letters. All right, y'all. I appreciate everybody. I will see y'all either tonight. I won't be able to see you tonight because I won't be in the chat. I'll be on the TV. But tonight, or I will see you on Monday. I appreciate everybody. And maybe next week is the week.
Yeah, I gotta go. I can't stick around here forever.
It was wonderful. Everybody behaved. Everybody's always so nice to me.
Just love your channel. And
Goodbye. How the heck do I get out of here?
Court date that even though it's been 4 years, she is not ready for. She cannot handle this on her own. It's nobody who is not legal, even lawyers should not handle their own murder trial, right? If they're being tried for murder, you want somebody else to handle. There are too many moving parts and pieces. This subpoenaing witnesses, cross-examining people, calling witnesses, just trial strategy in general, working with the different motions in court.